Good morning, good morning, good morning, amazing law nerds. It's Tuesday. It's January 9th. We are back from break over here. It's so good to see you. I needed the break for sure. I've got my coffee. We've got a lot to talk about today. I was going to cover the Donna Adelson court hearing. All the courts are closed in Tallahassee. It seems that everything is closed today in Tallahassee. So stay safe. I see a lot of you dealing with storms today, as am I. And for those of you that were like, Emily was probably getting her coffee ready. Yes, that's true. Definitely have my coffee in the Starbucks Year of the Dragon mug, but I also couldn't find my reading glasses because I have been reading so many Courthouse Becky emails that my reading glasses have been all over the house because I am of the age where I have multiple pairs of glasses. And if I misplace one of them, I'm screwed. So since we're reading so many motions today with Murdaugh, I really needed my glasses. So let me know where you're coming in from and either what you're drinking or what your weather is. I love both. You know I'm a big weather fan. I knew that the weather was a situation today when I saw Ryan Hall, y'all covering like what's going on in Tallahassee and South Carolina and stuff. I was like, oh, it's gonna be like that today. So at the moment, it is chill here in Middle Tennessee. Last night had no chill. So I'm sure all of you are experiencing the same kind of weather we are. It's bananas, Bananas. So stay safe, stay dry, stay warm. May the winds not blow anything down that you don't want to have blown down. So with that, I'm going to have a sip of coffee. We're going to get rolling. I've got a few little updates. The members saw some of those last night. And then we're gonna just get into the audacity. I'm gonna tell you what I'm looking forward to this month. I think that might help so you have some idea of where the coverage is going. So maybe that'll help, maybe it won't. But on the break, I got to like sit down with my calendar and like go through all the court dockets and look at all the upcoming hearings. So I feel like prepared like an adult. I'm like, Judge Abby and I were chatting and she's like, what are you doing? I'm like, my court calendar. And trying to make sure I keep it in the right time zone depending on which court I'm calendaring. So it was nice to have a break to do. I didn't not work. It was just not streaming. So I was working so that I can bring you more content going forward because there were cases I just needed to catch up on. And it's when I say it's thousands of pages of reading, it's thousands of pages of reading. Like the Courthouse Becky emails are 2,000 pages. A lot of it's repetitive, so it's just like scroll. But there's some other cases popping off, and it's so many documents. We're going to talk about all of that in a minute. So let's roll. Let's roll the intro. It's good to see you guys coming in. I've missed you. Happy New Year. Here's to 2024 being the year of find out for all of those who chose to fuck around in 2023. Let's go. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. I missed you guys. My coffee is so good this morning. It's so good. For those of you that asked, and I saw a number of you ask, did I get the Starbucks X Stanley mug? No. Did I get the Target Stanley mugs? Also no. No, there were no new Stanleys. This was the mug that I really wanted for the New Year collection, and I tried to show some restraint, so this is the one that I got. My youngest is Year of the Dragon. I love dragons. There are dragons all in my background, in the background that you can't see. We redid a bit of this background, so to let the light shine through, to put up the gift I got from YouTube and the rest of it. So I did like a full office overhaul during the break. I took everything out of every shelf, and some of it is still against the wall in a pile off camera, but I took everything off of every shelf, cleaned everything, steamed stuff. Emily, what content do you watch when you're not doing legal stuff and you're not reading legal stuff and you're not watching reality TV show meltdowns because there might be legal stuff? Cleaning videos. Watch a lot of cleaning videos. So everything is now clean and I feel so good. Did I play the podcast intro? I might have. I was recording the podcast last night. I sure might have. Yep, totally possible. Welcome to 2024. We're just going to roll with it. It's fine. You guys know what it is. So for those asking how the shelf cleaning went, good. It feels clean. It feels good. Things were dusty. Things needed to be clean. The windows needed to be clean. It's just all the things. For those of asking what YouTube gave me, it's up on my Instagram. So, wait, Emily, thoughts on soap cutting ASMR? It only causes me anxiety because I worry people are going to slip. So when I see people with like the blade in their thumb, it makes me nervous. I don't hate it, but it makes me nervous. Did you rig the lights for Audacity green? Yes, I did. We're ready for today. We're ready for today. Today's going to be wild. So let's do, since I played the wrong intro, let's just quick bits it and we'll just do a few little housekeeping matters. We're easing into the new year, people. We're trying to ease in. I don't know about y'all, but I'm not ready for like it to be circle back time. It's like, we'll circle back in the new year. And it's like well into the new year now because New Year's Day was on a Monday. And I'm like, I'm not ready to circle back yet. Like I'm just not. So let's get into quick bits. Quick bits. So for those of you having some YouTube issues, try refreshing on YouTube's end. That might help. Let me give you an idea of what's coming up this month. We were supposed to have a Donna Adelson court hearing today. I imagine that will be coming up in the coming days. So when it comes up and when we have the date for that, I will cover that either live or right after it airs. So we will be covering that scheduling hearing. There's a new podcast dropping tomorrow for the Emily show. You guys got a preview of my podcast intro. There's a new podcast dropping tomorrow. I go through all of Tom Girardi's court order finding him competent to stand trial in the criminal case in California. The judge had some sass for him and basically, I'm completely paraphrasing, but calls him a liar. I mean, the word malingering basically means faking faker, and also says that he is exaggerating his symptoms. So there's a lot of really interesting and new information in that order. I also go through, for those of you that watch VPR, I go through briefly through the Ariana Tom lawsuit that is going on for a partition of the property. And we talk about equitable division of the assets and what that looks like when you're cohabitating and you've purchased a house 50-50 and you're separating but not legally divorcing and what the court's doing there. So I pull up that lawsuit and go through it. It'll probably just go into mediation and force a sale. I hope that happens quickly for both parties so they can move on. On Friday, there are some documents due in the TikTok defamation case. So hopefully early next week, we'll have more information on that. On the 16th, there is both a Murdaugh hearing and a really big hearing in the Remini Scientology case. So on the 17th, I'll be doing a podcast covering the slap motions that are going on. There are so many motions going on in the Scientology case. I'm just going to do an overview podcast so you guys can have all of the info. But the judge put out a minute order literally saying enough is enough. Like that's literally what it says in the minute order. Not me being exaggerative, not hyperbole. The judge saying enough is enough. So there is a ton going on there, and I'm going to give you an overview of what's going on. I don't think we're going to have any resolution on the 16th. I think it's going to be taken under submission. It's pretty complex arguments. Slap motions are very complex, and judges normally take those under submission. So I will kind of overview the oral arguments from the 16th, and if we need to break down that hearing, because it should be filmed, I will break it down. I don't know if I'll be streaming the 18th. I'm going to be traveling. I'm speaking at a conference. Then why is my calendar going crazy? It's like jump around. Then later in the month, we have Becky Hill's son is supposed to be in court for the wiretapping arrest. We have an Idaho hearing on Friday, the 26th. I'll be covering that hearing live. It's the first hearing that's going to be streaming directly from the court. The court put out a new order about that yesterday. I'll talk about that court order in a minute. I'll just pull it up so we can all see it together. And then the last week of the month, it's all Murdaugh. The Murdaugh hearing is going to be the 29th, tentatively through February 1st, but maybe just the 29th, 30th, 31st. So the end of the month is going to be the Murdaugh hearing. I'm going to cover gavel to gavel that evidentiary hearing. We can't not. We're too invested. I'm too invested. We have to know. So we're going to hear the evidentiary hearing regarding Courthouse Becky. The fact that they left it for 3 to 4 days, I think they're going to try to bring in the jurors too. We have so much to cover. So that's a lot of what we're covering this month. In other quick bits, we are going to have a Brittany update in there somewhere. There has been movement at the last court hearing. There's going to be depositions that need to be done by the end of the month. With regard to Brittany, Lou Taylor and Lou Taylor's associate are going to be deposed by the end of the month. So there's depositions that should be happening as we are only a few months away from that 12th accounting trial in May. So we will do a Brittany roundup as well. So those are kind of the things that are on the radar. Of course, other legal stuff will pop up. The Law Nerds last night in the members only, and it was a members only behind the scene podcast recording. Those are live when they're live. They're generally on Mondays. And it's like, we're recording a podcast. We're live now. But a lot of you asked me about the defendant that leapt the bench and attacked a judge in Las Vegas. We're going to talk about some of that in a members only stream. I just don't think we have time to do it on a stream. For all of those asking about the Reese's lawsuit, yes, we will do a food court at some point, and Reese's is in there for sure. So there's so much stuff on the docket, and that's not even including the other cases we need to circle back to. So on top of mind, we need to get back to Corey Richins, but I haven't seen a lot going on. We will at some point pick up the Karen Reed case in Massachusetts. I have not decided when we're picking that up. We might just pick it up and watch it as jurors. We might pick it up sooner. I haven't decided. There's stuff going on in the Amber Heard insurance case, in the David Dobrik insurance case. There's filings in the Lizzo case. There's more filings in the Blindside case. We've got the 12th accounting. The Motley Crue case is they're trying to force it into mediation. So we need to look and see if there's a ruling. We have a lot to cover. And that's not even all of them. Oh, and then we have that sentencing February 20th to case closed on Jody Hildebrandt and Ruby Franke. Thank God. We're just we're done with you. Early 2024, we're done. We're done. Goodbye. I'm looking forward to that. I'm ready to say goodbye to both. Goodbye, Kyle. The amount of Housewives references you're getting today. All of us to Ruby Franke. You can leave. So with all of that, I've been reading through all of the Courthouse Becky emails. Over 2,000 of them were dumped in a FOIA request made by Fitz News. I have been going through them myself. There's been reporting on them. I wanted to go through them. I just wanted to go through them myself. I realized that people are capable of reporting, but there were things that I've taken away from it that I haven't seen reported. I haven't finished all 1,000 or 2,000 pages. I've gotten about halfway through. So we might talk about some of that today, depending on how much time we have. So I'm keeping questions for sure. I've got them. I've seen all of it for sure. But first, we're going to thank everyone who's gifting. Thank you, Laura Christie, for the gifts. Thank you, Monuments to the Gods of Speculations, for the gifts. Thank you, Stephanie Morgan, for the gifts. Thank you, Lisa S., for the gifts. Thank you all for the membership gifts. For those of you that become new members, you can go watch all the members' content on the channel, all the members only live streams and such. So, Lynn B said, so much interesting stuff coming up. It's busy, y'all. When I say I'm trying to plot out what we're covering, it's just because I want to read all the documents. And the Scientology paperwork is not only $700 worth of court documents. Emily, do you wish you had spent that money elsewhere? Maybe. But not only is it tons of documents, but it's thousands of pages of shit to go through. So some of it's valid. Some of it is paper for the sake of paper. And we know that that's going to happen, right? We know that that's going to happen in that case. And so we're just trying to make sure that we look at everything. And I look at all of those because the things that might be important to me might not be important to a reporter. And that's really important to me. Because reporters are looking for maybe different stories than the things I'm looking for. So that's why I want to go through it myself. And I think part of the reason you're here is to see me go through it. So while I will use people's reporting to supplement information or to look at what people are saying, I want to read the court documents myself. And if there aren't court documents that I have, I will absolutely tell you, because then we're not going to go through them. All right. Are you ready for a day of murdacity? A full day of murdacity? Look, a full day of murdacity. We got murdacity. Let's just do that. Let's just do that. So, Noya said yes, the Karen Reed case. Yes. I know it's getting ready to go to trial. I know they are deep in all of the discovery fights. I just need to decide with how busy the cases we're covering are, if we're going to watch it as a jury, or if we're going to watch it, or if we're going to look at the motions beforehand and go more in depth with it. I haven't decided yet. So I will let you know. There's times I really like going into a case as the jury and being like, convince me. Like, I didn't look at a lot going on in this case. I didn't look at the things going on outside the case. I don't know what was admitted into evidence, what's not admitted into evidence. I don't have any opinion. Tell me your case and talk to me like I'm a juror. And so I do have some interest in maybe doing it that way. And so that's why I haven't taken a dive into that yet, because I'm really, really interested to see how this case gets presented just from the little bit I need. For those of you asking about the Sarah Boone case, I have no confidence that case will ever go to trial. I am keeping like a side eye on the Sarah Boone case. I don't know what is ever going to happen. I don't know what's ever going to happen with that case, but it's a side eye. So that's what we're going to do. But today we're deeply, deeply invested into Alec Murdaugh, his lawyers, and all of the tangential surrounding fuckery, because God, there's like a cottage industry of fuckery around this case at this point. And I'm here, like, there's gossip, there's speculation, but there's also evidence, receipts, timeline. I've been watching too much Real Housewives of Salt Lake City. I have. Okay, let's fly into South Carolina, though. I don't know if you can easily do that today, but we can, because we're Lawnards. All right. Welcome to South Carolina. That was easy. Weather's nice. Weather looks a lot like wherever you boarded from. Here's where we're at. Here's where we're at with Murdaugh. We are covering today the motions in the new trial motion. So for a brief rundown, Alec Murdaugh was convicted. Post-conviction, his attorneys filed their notice to appeal. Dick and Poot et al., or Poot and Jim et al., filed their motion to appeal. After they filed their motion to appeal, they filed a motion to stay the appeal, to pause the appeal, so that they could make another motion for new trial back in the lower court, like the trial level court. A lot happened with that. They asked that Judge Newman be recused. Judge Newman actually yeeted himself off of the case and was like, I'm off of this. That's fine. And with all of that, we now have this motion for new trial that looks like it's coming for a hearing at the end of the month, an evidentiary hearing with regard to the motion for new trial. The allegation is that the clerk of court fucked with this jury, that the clerk of court, Becky Hill, who sometimes signs her emails Becca Boo, but so far only if she's talking to Nancy Grace, Becky, who I have started calling Courthouse Becky is alleged to have messed with the jury. And even with the jurors that seem to have say they weren't persuaded by Courthouse Becky, it seems that Courthouse Becky had some conversations with the jurors beyond we're having lunch at this time today. Like, the clerk of court should only really say things like, lunch is at this time. Do you have any allergies? Do you want, chicken or beef? Like, they should be housekeeping matters. Oh, do you need another blanket? It's cold in here. Do you need any pens? Like, it should be very surface level comfort level things, like fighting for lunch, making sure the jurors get fed, making sure parking is taken care of, those kinds of housekeeping matters. Never a conversation about what the jurors think, what they think of the evidence, and the rest of it. Never. No one should be talking to the jury about any of that. The jury shouldn't be talking to the jury about any of that. Remember way back when Cardi B sued Tasha K and it went to trial? One of the jurors was at lunch talking to another juror and said something along the lines of, can you believe all that like YouTube stuff? And the juror said to the judge, hey, this juror at lunch said this. And the judge is like, I'm sorry, that's talking about the case. And the juror was kind of like, that was crazy, right? Like, you're talking about the case, you're gone, and yeeted that juror. You can't talk about the case, especially the court staff. So that's the allegation. There was rumbling about whether these allegations were all planted by Team Murdaugh, whether this was exaggerated, whether, is Courthouse Becky a tried and true servant to the public who was elected as clerk of court because she loves her county, or is she a power-tripping mean girl who thinks she can get away with anything that she wants? Is this power run amok in this courthouse? That's really the question here. So then it started to come out, mostly because jurors are pissed about the book. Look, y'all, they said they were unpublishing it. We're going to talk about this. This is evidence. This is not actually a book for reading. This is evidence. I bought the book after they said it was pulled, so it's not down yet. But some of Nick's in the chat saying amok. Exactly. This book pissed off a number of the jurors because of what was said about them in a book. Should a clerk of court ever be talking about jurors in a book? No. You don't gossip about your jurors. So, is this power run amok? Then there's the book. Then her son gets arrested for wiretapping. He's the head of IT for the county. He eventually gets fired. He's pending that case. Her cell phones get taken as part of that investigation. We get this FOIA dump of all of her emails, seeing what she's actually up to from her work email during the Murdaugh trial. And yes, in those emails, she's absolutely asking people what they think the verdict will be. And she's absolutely indicating that she wants this verdict to come back, not just swiftly, but correctly. So you can tell from her emails that she thinks that he's guilty before the jury comes back. You absolutely can. It's absolutely in the emails. Read it for myself, amongst other things that we might get into later. So then you've got the email dump. Then you've got all of these 2 ethics complaints about whether or not she was letting people pay for access to the courthouse and taking that money so that they could do tours, whether she was closing court to let film crews come in to benefit her and maybe sell more books because she's in a Netflix documentary or whatever. Generally, people aren't paid to do those things, but it doesn't mean it can't benefit you in some way. So it's all this other tangential stuff that started coming up, including her emails, her son's arrest, statements made, and the rest of it. So from the beginning, it was like, is this a stretch on Team Murdaugh's part? And that has been walked back and walked back and walked back more. The more that comes out about Becky Hill, the more this gets walked back. It's so funny because at the beginning of Becky's emails, it's like Becky's talking to somebody and she's like, I'm so torn because, I know this family and I know the Murdaughs and I've always had tremendous respect for them. And then midway through, she's basically like, fuck this dude, he's guilty. That's a paraphrase. She did not say that in the emails. She's like, do you think it'll be guilty? We need justice to be swift and strong and correct and all this other stuff. It's an absolute mess. And then the person that her son is alleged to be wiretapping is somebody that Becky's interacting in emails with because it's another county official. And then Becky's petty Betty fighting with the finance department. Oh, bitch, we'll go through that whole email at some point. That's where the tea is. The tea is with Becky going like full to the supervisor and being like, this is unacceptable that I'm being questioned. Okay. And then she's accepting gifts. Okay, we have to get to these motions. She's accepting gifts. She's an elected official. You can't accept. I realize that there are members of the public. When I was a DA, there were members of the public like, can I send you something? No. If you want to send me something, the only thing you can really do is send a letter to my boss and tell them that you thought I was great. Like, that's it. You don't send me flowers. And people would ask on occasion, can we bring donuts? Can we send flowers? Can we do something after all your hard work? No, you can't. I'm a county employee. I'm doing my job. You can't send me gifts. I appreciate the thought. That's very kind. If you want to send an email to my boss saying that you think I was great, that'll go in my file and that's helpful. But there are people from that she got seats for that are like, can I send you a t-shirt, a scarf? Like, well-meaning things, but she's an elected official. You can't accept gifts. And then there was a birthday party that was hosted for Courthouse Becky, and it looks like there was one for Valerie Ballerellen as well, that was partly paid for by one of the attorneys that's a good friend of Dick Harpootlian, who's also representing some of the jurors. No, not even muffins for the chat. The chat's like, they can't bring you muffins. No. Mm-mm. And you can't accept things, especially as a DA, because you never know if people are actually bringing gifts in a good way or in a bad way. But you're also a government employee. Like, you're not accepting gifts. And I have friends that are judges who are just like, if somebody wanted to bring their court staff gifts, they would be like, thank you, that's very kind, but we can't accept gifts. We're government employees. And the judges generally give gifts to their staff or give them days off if they can after a trial like that. But they're not supposed to be accepting gifts. So there were emails where people were like, Becky, what can I send you? And she's like, oh, you don't really have to, but if you insist, here's the address. Becky's daughter was also like singing. It seems, I need to talk to one of the media pool members that was over there, but it seems that Courthouse Becky's daughter, seemingly adult daughter, but I'm not 100% on that, was performing over at the like the wildlife center where the media was, with like a guitar case open, which is odd, but whatever. And one of the journalists wrote into Courthouse Becky and was like, hey, I didn't have any money to put in your daughter's guitar case. Can you send me her Venmo? And so Courthouse Becky's like, here's the Venmo info. And I'm like, what are you doing? What are you doing? What is happening? So there's a lot in those emails, which is why I wanted to go through it. Okay, let's go to the motions first. We'll talk more tea from the emails. It's just wild. It's just wild. Becky said, just when the other Becky memes have died down. I'm sorry, Becky. Should we just call her Becka-Boo? Would that make life easier for you? Becky, I want to make life easier for you. It's not your fault. Should we just go with Becka-Boo? Becka-Boo. It's wild. It's wild. It does. Carol said, never saw conduct like this from court staff during my 30 plus years as a trial lawyer. Carol, same. And there was, when in criminal courts, there were definitely times where the DAs would all bring in breakfast to the DA's office and tell the court staff that there was stuff there if they wanted to come down and get it. But, there were times that people brought clerks, the lawyers would bring things to the clerks of court. But what I'm seeing in Becka-Boo's emails is that they are people that she got seats for. We're moving on, I swear. The seating was supposed to be first come, first serve. And there was a order put out, a media order that had a limited number of outlets that were reserved seats. A limited number of outlets. And the court reserved seats for a lottery pull limited number of outlets. By the way, Law and Crime was not one of the outlets, and they were salty in those emails about it. Which they were like, why weren't we included? Which I totally get. I'm like, why aren't I on the list? But Law and Crime was not on the list. So there were a limited number of outlets that got reserved seats. Everything else was supposed to be first come, first serve. Half of these emails, that's an exaggeration, I didn't actually count. A substantial number of these emails are either people that knew Becky, people that had formed a relationship with Becky, other media outlets that Becky wanted to work with or benefit in some way, that would be like, hey, can I get tickets for this day? a lot of people who were local attorneys, local commissioners, people local to South Carolina, and Becky would hook them up in the email and be like, yeah, come to the side door. Yes, that's the correct word. That's the correct word, Airy Deary. Curry favor. Yes. Yes, that's the correct word. And so she would have like, hey, we've reserved you tickets, come to the side door. So it wasn't really first come, first serve. It was like reserved seating for journalists, beneficial seating for people Courthouse Becky reserved seats for and told to come to the side door, and then first come, first serve for everybody waiting outside. Wild. Wild. Ryan Blackhawk asked the question y'all are asking, has she been fired? She's an elected official. No, she has not been fired. She's an elected official. Did she think people wouldn't find out all of this? I don't think she ever thought that anybody would do a Freedom of Information Act on her work email. Just a reminder, if you work for the government, your shit can be FOIA'd. So that's Law and Crime really hurt Court TV's Jan. It's really Jan. Yeah, Court TV had reserved seats. So it's wild. Come to the side door is shady unless it's your house. I mean, it's really some wild stuff, seeing people just being like, oh my God, my husband said we could just reach out for seats. But it was also like, it wasn't just people that seemed to know Becky. It was, a high school debate team that was local. She was trying to take care, it seems, of those that were local and those that she knew. But I have no idea if Judge Newman knew this was going on. Judge Newman said, these are the media reserved seats. The rest is first come, first serve. And it most certainly was not first come, first serve. It was reserved through Becky, and then first come, first serve. And she was talking about her book with journalists. There's one journalist who's like, I'm not on the reserve list, but can I get a pass? I'm writing a book. She's like, oh, I want to write a book too. We can chat about it. Like, that's all in there. JD said, Janie is expanding my reminder. If you work anywhere, your email can be subpoenaed. Yes. It can be FOIA'd if you work for the government. It can be subpoenaed if there's cause to. Any updates with texting judge? We not today. There might be down the road. Let's see. Why do I imagine Becky being like, why are you so obsessed with me? I mean, maybe. Reserved through Becky is like the Starbucks secret menu. BJK said, had a friend in law enforcement. She actually had an Apple phone for personal and an Android for work because she didn't want her personal stuff FOIA'd. Most people that work in government or law enforcement will have a personal phone and a work phone. And they're always told, especially with the rise of cell phones, because I was working, I'm so old. As I was a DA, the first, iPhones were coming out and phones with cameras were coming out. And at the time, not all of law enforcement had cameras in their cars. I had one case where they had a camera in their car that had black and white film in it. Let me tell you what it's like trying to explain a blood trail on black and white film, because the defense attorney's like, could be anything. And I'm like, fair. It's in fucking black and white film. So there were issues with camera access in law enforcement back in the day. But we were always reminded, you can't just bust out your personal phone and start taking pictures, because if you're taking work pictures on your personal phone can get FOIA'd. FOIA'd, for the chat, is Freedom of Information Act. It can get requested and disclosed. So if you're taking like work photos on your personal phone, because it's like, oh, I've got a camera right here, you can't do that. So this was back in the day when they still had to wait for CSIs to show up with the crime scene camera. Depending on the crime scene, there weren't always enough CSIs to get things photographed. The cameras in the cars were still manual cameras. Not every cop knew how to like focus. The amount of fucking blurry crime scene photos. So anyway, let us go into, we're going to start with the defense's motion first. Why? Well, some of it's shady. Oh, let's talk about what the judge did. The judge that's been assigned to this case has said that all of the docket items, all of the filings are going to go through the Supreme Court, not through the Colton County Clerk of Court, because the Clerk of Court is the one who's alleged to have been tampering with the jury. So they set it up so that this case, even though it's going for new trial motion, it's being filed elsewhere. The judge is like, what we're not going to do is fuck around with anything at all. So let me pull that first motion. We're just going to go through all the motions today. So I will name them out. They will be timestamped below. Replay crew, love you. Let's get into it. We've got so much to talk about. Let's get into the first order, shall we? All right, Emily, I know the coffee's delicious, but maybe share your screen. Maybe be prepared. Look, y'all, it's the most Mondayest Tuesday ever after a holiday here. All right, let's make sure you all can see. Oh, that's right on the line. Okay, good. Supreme Court of South Carolina, Murdaugh, State versus Murdaugh. With the Honorable Clifton Newman presiding, the defendant was convicted of the murders of Margaret Kennedy Branstetter Murdaugh and Paul Terry Murdaugh on March 2nd, 2023, and sentenced on March 3rd, 2023. On October 27th, defendant filed a motion for new trial. I find that Judge Clifton Newman has requested to be removed from all post-trial matters related to the above referenced matters. It is hereby ordered that the Honorable Jean, that doesn't say heifer, Hofer, Emily, stop watching so much Housewives. Jean Hofer Toll, retired Chief Justice of the Supreme Court of South Carolina, be assigned exclusive jurisdiction for the limited purpose of presiding over defendant's motion for a new trial in all above matters. These, because everything has its own number. So these are the murders and the assaults with deadly weapon. Justice Toll shall decide all matters pertaining to these cases, including motions to appoint and relieve counsel, and shall retain jurisdiction over the case regardless of where she may be assigned to hold court, and may schedule such hearings as may be necessary at any time without regard as to whether there is a term of court scheduled. South Carolina runs their courts in a different way. So court terms are not something I ever had to deal with, because like we do this shit Monday through Friday unless it's a state holiday. But the Supreme Court said you're assigned, do what you need to do. So that's where we're at. You're assigned, do what you need to do. This is filed. This is out of order. Hold on. You're out of order. No, you're out of order. Where is the... That's the defense pre-hearing motion. This is the media coverage motion. Here we go. Media coverage motion or media coverage order. We're going to go through, as I said, we're just going through everything in the court file together today. State of South Carolina versus Murdaugh, order regarding media coverage for post-trial motions, prohibited equipment and activities. The Supreme Court authorizes presiding judges to prohibit possession of cell phones and other electronic devices in South Carolina courtrooms when the court concludes the devices interfere with the orderly administration of justice. For this hearing, the prohibition is to include cell phones, computers, except those used by the parties in court, smartwatches, earbuds, and other electronic devices capable of receiving or transmitting communications outside the courtroom, provided, however, that representatives of news organizations having assigned seating may possess cell phones and laptop computers for the sole purpose of note-taking. No emails, right? With the exception of the personnel engaged in gathering and disseminating audio and visual images for the news pool, no person may photograph, videotape, record the proceeding. Briefcases, backpacks, bags, boxes, and cases are prohibited except those in use by hearing participants. Spectators, including news organization representatives, will be prohibited to bring personal items into the courtroom, provided the items are permitted to bring in personal items in a clear plastic bag. The news may bring in a phone or a laptop for note-taking and personal items in a plastic bag. Representatives of news organizations sitting in reserved seating may utilize handheld micro-cassette recorders that comply with the rule of courts and provided above cell phones and laptops for note-taking. Pool coverage. Rule 605 governs broadcasting, televising, recording, and photographing court proceedings. That rule and its provisions apply throughout the duration of the hearing. The order is entered to provide information regarding pool coverage. Modifications may be required. Court TV will serve as the pool representative for the acquisition and distribution of television, images, and audio. Court TV will disseminate to pool recipients its mixed feed, which will contain images and audios selected by Court TV to reflect as accurately as possible the proceedings. Here's the issue with the mixed feed. What people are asking for is generally not the mixed feed. So this is going to get into the weeds a little. Just give me a second and then I'll wind myself back out of the weeds. But if Court TV is filming on 4 cameras, all 4 cameras are going to go into a, field producer or whoever who's going to then mix them and switch between the cameras. Court TV will sometimes feed out constantly the feed of all 4 cameras so that other networks can either air all 4 cameras at once or they can mix their own feed when they see it necessary. Court TV is told that they only need to pick out the feed that they're mixing. So they choose the camera angles. So if you're looking through camera A and there's a shot from camera B, you're not going to see what's on camera B until they mix camera B into it. So they're not feeding out their raw coverage. They're only feeding out their mixed feed. Court TV will make no claim for copyright with respect to the audio and video disseminated to pool recipients. Court TV may license images and audio obtained at the hearing to organizations which are not participants in the pool coverage. The state newspaper and perhaps others will provide still photography coverage of the proceedings. Still photographers will make no claim of copyright in photos obtained during the hearing. They will retain copyright of any images obtained outside. To the extent possible, still photographers will be allowed to photograph for distribution to pool participants, documents, and other materials admitted into evidence at the hearing. Courtroom reserved seatings, and then this is the list of who is allowed in for courtroom reserved seating. Hampton Guardian, Walterboro Press and Standard, the Post and Courier, the State, the Island Packet, the Wall Street Journal, the AP, Fitz News, Luna Shark Productions, Impact of Influence, Alphabet Soup of stations, including ABC, CBS, NBC, CNN, Fox News, SCETV, Greenville News, USA Today, Law and Crime. Pool participation. It was never the intention of the Supreme Court of South Carolina to adapt a court rule requiring pool representatives to serve as remote bureaus for news organizations not present for the proceedings in the case. To that end, only those news organizations with a representative present in Columbia for hearings in this case will be deemed pool participant for purposes of receiving the court TV feed or having access to pool still photography, which is going to change things for the streamers a little bit, right? Because Court TV is allowed to license it to people who do not have a representative on site. A media liaison is appointed. The media liaison is there. Duration, the order shall remain in effect for the duration of the consideration of post-trial motions unless modified by court order. So, the judges said basically, if you do not have a representative in court, you are required to license the footage. Isn't that interesting? So it's going to make restreaming it interesting. So with all of that, that is the court's media order and who is allowed in the courtroom. Let's see. There's a motion for discovery that says you guys need to exchange things. There is a motion and order regarding how the filings are going to happen. Let's go through that real quick. Purple says licensing public trials seems off. Agreed. So, let's see. Tyann said, tag me and I'll go sit there. I'm going to reach out to the media pool about licensing. So, but yes, it allows Court TV to be in a position where they can license footage to anyone who's not there, which is an interesting thing, isn't it? All right, let me make this a little bit bigger. This is the court order from January 3rd. Again, all of this happened the week I was off. It was like the courts just came in hot back from break. They're like, let's go. Defendant was convicted of the murders. We know that. We know the order dated on the 18th. We read that order. Here's the addendum to the order. It's not a real addendum. It's more like a PS. Therefore, it is ordered that all documents, orders, and correspondence related to the resolution of defendant's motion for new trial shall be filed with the clerk of the Supreme Court of South Carolina. Upon receipt of this order, the clerk of court of Colton County shall transmit a copy of the defendant's October 27th motion for a new trial, together with any and all subsequent filings in the above cases, to the clerk of the Supreme Court of South Carolina. The parties may file documents with the Supreme Court by electric means in accordance with case law. The parties shall supply Justice Toll with copies of all documents filed in whatever manner she directs. Justice Toll shall provide the clerk of the Supreme Court with any written orders for filing. The clerk shall provide written notice of filing and entry of those orders to the parties in the case. Public availability of filings is at C-Track. So, because this is a Colton County issue, and because defendant's motion for new trial contains allegations related to the conduct of the Colton County Clerk of Court, I find it would be inappropriate for documents in this case to be filed in Colton County. So the justice is like, I see room for fuckery. And what we're not going to do on my watch is fuckery. So the court was like, you're not getting access to the documents. I mean, you can get the public documents, but you're not in charge of the documents. So Courthouse Becky, the clerk of court in Colton, would have been in charge of all the filings, and they took it right out of their hands. So that is what is happening. Let's see. Where is the next one is going to be the defense pre-hearing motion. This is the one where the T is. So we're going to do the defense pre-hearing motion and then the state pre-hearing motion, but I felt that it was helpful to set the ground for why these things are being filed in the Supreme Court, how they're being filed in the Supreme Court, even though this is a Colton County case, even though it goes technically back to Colton County. I don't think the hearings are actually going to be in Colton County, et cetera, et cetera. All righty. State of South Carolina, County of Colton, Court of General Sessions, 14th Judicial Circuit. Defendant Richard this is defendant's motion for pre-hearing brief. Did I swoop? Y'all, I'm brand new today. 2024. We're brand new. Let's swoop a dupe. Let's swoop it up. Defendant's pre-hearing brief regarding motion for new trial. Defendant Murdaugh, through undersigned counsel, submits this pre-hearing brief. Introduction: Mr. Murdaugh was indicted for the murder of his wife Maggie and son Paul on July 14th, 2022. His murder trial began January 23rd, 2023. The presiding judge was Clifton Newman. Trial ran for 6 weeks, ending with convictions on the evening of March 2nd, sentencing March 3rd. On October 27th, Mr. Murdaugh filed a motion for new trial based on after discovered evidence, having obtained a leave from the Court of Appeals to suspend his appeal and to suspend his appeal of his convictions and file the motion. His motions allege that Rebecca Hill, the elected clerk of court for Colton County, had extensive private communications with members of the jury during trial. This allegation was supported by sworn affidavits of jurors and a witness to juror interviews. Yet those are hearsay. The witness swearing an affidavit, like I heard this person say this, is it's like hearsay defined. I heard a person say this. It's in the name. Those are kind of irrelevant. The sworn affidavits of jurors, more relevant. Testimony at in-camera proceedings and other evidence, including Miss Hill's own book. We'll get to the plagiarism of the book real quick. For those of you that aren't following every twist of this case obsessively, I completely understand that you have a life and it was just the holidays. Becky Hill is admitted to plagiarizing the opening of this book from a BBC article that was accidentally emailed to her. Yes, the email is attached in all of her stuff, and her co-author disavowed her essentially and admitted to the plagiarism. She admitted to the plagiarism and apologized. So we'll talk about more of that later. But the book is depublished, but you can still buy it. So we'll see. Mm-hmm. Let us continue on. The subject matter of Miss Hill's alleged communications was the evidence being presented by the defense at trial. Mr. Murdaugh alleges that an elected state official deliberately violated his constitutional right to a fair trial before an impartial jury. If the allegation is proven, the law requires a new trial. For those of you that didn't hear about the plagiarizing, yeah. We needed the context before we go on. There's too much in my brain. Mr. Murdaugh does not need to show actual bias on the part of any juror to obtain a new trial. So this is getting into the defense's legal arguments about whether or not we need to show that the jury was impacted. The defense is really arguing we just need to show that like she spoke to the jurors about substantive stuff. The other part is the state saying, but even if she talked to the jury, you need to prove that the jury was impacted. So those are the legal arguments that we're going to be working through, but that's kind of the overview summary, the 30,000 foot summary or whatever. If Mr. Murdaugh proves his allegation that Hill communicated with the jury about the evidence presented by the defense during his murder trial, South Carolina and federal law require that Mr. Murdaugh receive a new trial. Irrespective of whether the court, let me make this bigger. I was like, why does this look so small? Irrespective of whether the court believes the outcome of the trial would have been the same had Ms. Hill's jury tampering not occurred. For those of you that are going to ask, isn't this criminal behavior? We'll get to that later. This is just about whether or not the clerk of court interfered with the jury in a way that requires a new trial. Quote, a defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury, and in order to fully safeguard this protection, it is required that the jury render its verdict free from outside influence. Is there any case law about a clerk of court doing this kind of stuff? Not that I've seen, but there is lots that deals with things said by bailiffs. Bailiffs are normally charged with the jury. So there are cases where bailiffs had said things. Often they do not result in a new trial. This is a very high hurdle to overcome. Sidebar, real quick. No! I need to switch those buttons around. I constantly hit the wrong one. Sidebar. Remember the Maxwell trial where the juror left stuff off of their juror intake form, including the fact that they had been a victim of the same type of crimes that were being alleged against Maxwell related to the JE stuff? I can't even say the name without YouTube losing its mind. So chat, you know what I'm talking about. There's an island. There's lots of unsealed paperwork coming up. Sounds like Schmepstein. That case, the juror had left stuff off of the juror questionnaire. And the defense was like, had we known this, we might have removed the juror. And then they went through all the juror questionnaires and they're like, well, you didn't remove every juror. And they're like, well, we would have questioned them more. So the court questioned the juror and did not order a new trial, even though the juror had left off information that might have been relevant to the defense. And the court was like, this isn't enough. Because we questioned the juror and the juror's like, look, this didn't impact my verdict. And the court's like, good enough. And then that one, I was like, oof, that doesn't look good. Like, that's not good. That's not good. There's going to be a podcast episode talking about the Maya juror that was interviewed, about this case, and about the Maxwell case. It's like Maxwell, Murdaugh, and Maya, and jurors getting interviewed and all the rest of it. We're going to talk about that and whether this is a new wave of high-profile trials, that this is just going to start happening more. That's for another day. We're very busy. But we're going to go through some of these cases together and look at it and look at the standard. So we're going to look at the standard in South Carolina for sure. Where, and this is coming from South Carolina case law, where, quote, there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. A new trial must be granted unless is important. unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Hey, do you need Kleenex? Chicken or beef? Hey, we're having lunch a little later today. Hey, we're going on a jury view tomorrow. You might want to wear shoes in case there's, you might want to be prepared with the outdoor shoes in case there's mud. We're going to be outside. Bring an umbrella, those kinds of things. Harmless matters. Speaking to the jury about harmless matters. If the subject matter is about the case or the defendant in any way, I think we've got a problem. The law requires the subject matter of the communication be harmless, clearly harmless. Otherwise, a new trial must be granted. Asking the jury what it wants for lunch is clearly harmless. Telling it not to believe the defendant when he testifies is not. I don't disagree with this, but it's premised on that's what she said. And I'm not 100% clear that that's what she said. Jennifer brought this up in the chat. We're going to get here. Creighton knew she was doing inappropriate things by sending emails to the prosecution, but then acts like he had no idea. Jennifer, we're going to talk about that for sure, because I have thoughts. Emily, have you ever had to question a juror post-trial? No. The only time I had this come up where a juror had to be questioned is when the judges wouldn't let us use the back hallway anymore. I'm still a bitter Betty about it. And Emily, are you going to get through this? We're going to take a brief story time. Some of you have heard this story. The courthouse where I worked at, we used to be able to use the back hallways. The back hallways, it was like courtrooms and then a giant long hallway like out of a horror film, and then the judges' chambers, and then like the judges' chambers had windows to the outside because of course the judges need windows. So there was a back hallway and back elevators so that you didn't have to walk in the public hallways and go in the front doors of the courtroom. You could come in through the back doors of the courtroom. When we would take breaks and stuff and wait for court to open, the problem would be to be on time, that the jury would often be waiting in the hallway with you. So this was one of the issues where we're like, we need to use the back hallways so we can get into court and start setting up before the bailiffs open the doors. So we're ready for trial when the jury comes in and we're not standing around the hallway with the jurors, because there is the potential for it to be a problem. The site judge at the time didn't want these DAs wilding out. Here's what I think actually happened. This is all speculation. But the DAs would regularly use the jury room bathrooms. And I think the court staff got annoyed that all of the DAs had chosen, and I'm sure the defense attorneys were doing this too, were using the jury room bathrooms, not when there were jurors in there. You always knew which courtrooms were in trial and which weren't, but designated those as kind of the poop bathrooms so you didn't have to use the office bathrooms. I think this was more about that. I think this is actually what caused the problems, is that the lawyers in the building were using the jury room bathrooms. But the jury room bathrooms are also the bathrooms that the court staff would use. The judges have their own bathrooms in chambers, but the court staff would use the jury room bathrooms. So the attorneys were also using the jury room bathrooms so that you didn't have to use the office bathrooms. So I think that's what caused the problems, is that everybody was using their bathrooms to deliberate and they got mad. This is all speculation, but it tracks. So you can't have the attorneys using the public restrooms. I've had issues with that, especially when in trial. Well, that's a story for another day. You can't have the court staff using the public restrooms because defendants' families are in there who could be really upset with court staff. And you've seen what happens when people are upset with court staff. So there are safety concerns as well. So the rule became that the attorneys were not allowed to use the back hallway and not allowed to use the jury room bathrooms and the rest of it. So we had to stand outside the courtroom waiting for the courtroom doors to open when we were in trial, but that's where the jurors are standing too. We're not allowed to talk to the jurors. The jurors say hello in the elevator, you put your head down. I wouldn't get into elevators when jurors were in there if I saw them, if I could avoid it. And this particular courthouse had a ton of escalators, so it was fine. Jury totally have their own bathrooms in this particular courthouse, but those were the bathrooms that people would use if that courtroom didn't have a jury. So it's like, oh, courtroom 5 doesn't have a jury this week. Okay, that's the bathroom. So this is absolutely true. Tiny courthouses and shared bathrooms are super weird and awkward. Yep. You got to find the right one. So I'm standing outside with the defense attorney. No, the defense attorney wasn't there at the time because I had to tell the defense attorney. I'm standing outside waiting for court to come back in. I am habitually late. So when I am in trial, I am over the top trying to be on time so I am not late because I don't like getting yelled at in front of a jury. It's embarrassing and I hate it. So I would overcompensate by getting to court early when I was in trial and then going back to being meh when I was not in trial. So I'm standing waiting to go into court. Jurors are there and one of the jurors tries to talk to me. And I'm like standing there saying nothing, like holding my files looking down. And the juror keeps talking to me and I'm like, I can't talk to you. Shouldn't have even really said that. Shouldn't talk to the jurors at all. But he wouldn't stop talking. And it's not like I can run away. I have to get into this courtroom and I'm not allowed to be in the back hallways. So then the juror tells me that I am an incredible woman and that after this is all over, we should go out sometime. In the middle of trial. So I have to disclose all of this to the judge and the defense attorneys when we get into court. And then the juror had to be questioned about all of this. And then the juror was removed. So it was mortifying. I was mortified. It was a very kind compliment, but I was mortified. And they tell the jurors that they can't talk to us. And I'm standing there literally with my files and my water bottle, like with my head down. But there's nowhere you can go. Like I'm just stuck there. So the juror had to be questioned. The judge and the defense attorney thought it was hilarious and teased me about it forever. This did not happen infrequently. Another trial I did with a defense attorney who I very much liked. She and I finished up trial. Her defendant was convicted. We interviewed the juror. Sometimes the jurors want to talk to you after the trial. Sometimes I would, sometimes I wouldn't, depending on the case. And the foreperson went up and asked her out, like while we're chatting. And was like, it was really incredible watching you in trial. I'd love to, get a drink sometime, blah, 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 blah. And she's telling me this in the back hallway. And I'm like, this happened to me in another trial. This is unhit. Like, who thinks this is the way to date? But she's like, they convicted my dude in like 10 minutes. She's like, obviously he doesn't think I'm that incredible. And we had a really good laugh about the whole thing. Though I do have a friend who got married to a juror on one of his murder cases. But the juror sent a letter to the office after the trial was over and was like, hey, I didn't want to be weird, but I think maybe we should go out sometime. This happens more frequently than you would think. It's so weird. Chat instead of Hinge, it's cringe. So why'd they kick you off the jury? Yeah, for people who are like, I would like to get out of jury duty, ask out one of the attorneys in the middle of the trial once you're already on the jury. I mean, that will definitely do it. Anyway, it was a thing. Sending a letter is kind of sweet. Sending a letter was like a less awkward way to do it. It was like, I'm putting the ball in your court. I'm letting you know that I'm available. You do what you want with that. It sends the possibility out there. They are married with children. So we're going to continue. Anyway, jurors. The back hallway, by the way, ended up changing their perception on the back hallway because it created too many issues. I mean, this is aside from all the times that defendants had tried to ask me out. But that's another day. Though I had defendants also accuse me of sleeping with their defense attorneys. And I was like, y'all, I'm very married and boring and tired. I needed to, nowadays, lawyers just put I'm Vanilla Baby on your phone as your ringtone and just play it when people start asking you out in court and just be like, I'm Vanilla Baby. So, anyway. Who knew courthouses were so romantic? They're just like hospitals. Everybody wants to hook up with everybody, it seems. All right, let's get back to this motion about Courthouse Becky and Courthouse Becky's allegation. The issue before the court is a structural issue in Mr. Murdaugh's trial, not a failure to impanel unbiased jurors. Where a new trial is sought based on biased jurors, where a new trial is sought based on the biases jurors brought with them into trial, The required standard is to show actual bias, whether those biases were facts jurors concealed during voir dire. That's what happened in the Maxwell case. Was this juror biased because they left something out? Were created by state action during voir dire. Resulted from jurors reading newspapers or other unauthorized materials, or from initiating inappropriate communications during trial, like asking out the lawyers. The present case is different. Here, a state official argued the merits of the evidence presented to the jurors during trial outside the presence of the court, the defendant, and his counsel, and in other ways deliberately and surreptitiously used her official authority to direct the verdict to her preferred outcome. It's not helpful for clerk of court that you can see her leaning towards guilt in her emails before the verdict. That's not helpful at all. I'm texting Dr. B because I want some more coffee. Emily, are you texting your husband to make more coffee? Yes. Let's see. Surreptitiously used her official authority to direct the verdict to her preferred outcome. This is, fortunately, a vanishingly rare event. Is that the right word? What word would you use rather than vanishingly? I don't know if that's the right. I feel like there's other adjectives. Anyway, a vanishingly rare event, but it is one that requires a new trial. The Cameron Court's distinction between the communication being harmless and the subject matter of the communication being harmless, and its requirement that the new trial be granted unless the later is established, recognizes that deliberate jury tampering by a court official cannot be cured or excused by the strength of the evidence presented at trial or jurors offering their own subjective opinions regarding their own biases. So the defense is trying to argue that even if the jurors say, I wasn't impacted by what Becky says, you can't necessarily believe them because they might have been impacted on a level they're not even able to recognize. Even if a juror, even if a juror were to testify that he or she would have reached the same verdict regardless of Hill's tampering, a new trial is required if it's proven that Hill communicated with jurors about the merits of the evidence presented. And of course, Hill is denying this, right? Sustaining a conviction based on the court's opinion of the strength of the evidence against the accused, regardless of improper external influence on the jury from court officials about the merits of the case, would effectively be a directed verdict for the prosecution. A statement that whatever happened at trial simply does not matter because the evidence can admit only one result regardless. That would constitute structural error, citing case law. For example, in Parker v. Gladden, a bailiff told a juror in a murder trial, that wicked fellow, he is guilty. Look, if you want to talk about tampering with a jury, a bailiff looking at a juror and being like, 1966, that wicked fellow, he is guilty, is a whole different thing. The Supreme Court of Oregon held the statement did not require a new trial because it was not shown the statement prejudiced the outcome of the trial. The United States Supreme Court reversed, meaning, Oregon, the state of Oregon's Supreme Court was like, and the jury was like, yeah, but we knew he was guilty. The Supreme Court of the US was like, no, that what we're not going to do. And said the evidence developed against a defendant shall come from the witness stand in a public courtroom where my phone fell, where there is full judicial protection of the defendant's right of confrontation, of cross-examination, and of counsel. We have followed the undeviating rule that the rights of confrontation and cross-examination are among the fundamental requirements of a constitutionally fair trial. So the Supreme Court was like, yeah, no, you can't do that. You can't do that. You can't just be like, that fellow right there, he's guilty. Sorry, I didn't mean to scare you with my phone. In Parker, the state also argued that the bailiff's statement was harmless because 10 members of the jury never heard the statement, and Oregon law at the time allowed a guilty verdict by 10 affirmative votes of the 12 jurors. They're like, look, hey man, 10 jurors voted guilty that didn't hear the statement, therefore the verdict stands, which is probably how The Oregon Supreme Court got to their reasoning. The Supreme Court of the U.S. rejected that reasoning, and after questioning whether the factual record supported that argument, stated that, quote, in any event, petitioner was entitled to be tried by 12, not 9 or even 10 impartial and unprejudiced jurors. The reasoning accords with the reasoning in Cameron 27 years later. The right being protected is not the right to a correct verdict, but the constitutional right to trial before a fair and impartial jury, free from state officials' improper influences. Free from state officials' improper influences. What matters is what was in fact said to the jurors by a state official, not a counterfactual analysis of what probably would have happened had it not been said. They go through other case law on this, but this all boils down that the defense's argument is if Becky Hill is proven to have spoken to the jurors about the facts of the case, a new trial is the only result. Full stop. No other analysis. The state is arguing the analysis is whether it impacted the jurors or not. The defense is like, we don't give a fuck if the juror was impacted or not. You can't do it. You are fucking around. You cannot talk to the jury in that way. The state misstates the controlling legal standard and provides no authority supporting its mistaken position. They're just like, what we're not going to do. In response to Murdaugh's motion for new trial, the state incorrectly asserts that Murdaugh must show both that the alleged improper communications occurred and that the jurors were actually biased as a result. The defense wants to argue that you just need to show that the communication occurred because Becca Boo is an elected state official. And so if there's an improper communication, their argument is just, look, that's all that needs to happen. The rest of it is done. The state is arguing the second part, that the jurors were actually biased. Were the jurors' opinions swayed in any way as a result of what Becky Hill is alleged to have said to them? The first step in any of this is you've got to show the communication happened. The state can cite no authority supporting that position. Well, where did this quote come from? Excuse me. We're going to get to the state's response in a minute. The state can cite no authority supporting that position. The state's response includes citation to several cases purportedly supporting its position, but not one cited case actually supports it. So now they're fighting over whether or not whose case law is better. Daydream said, how can they prove jurors were swayed? They would ask them. They would ask them. That's how. The state provides no parenthetical explanation of how Kelly supports its position because the case has nothing to do with the present motion. In Kelly, a juror was accused of misconduct, not a court official. During the guilt phase of a capital trial, the juror provided a pamphlet purportedly expressing God's view on capital punishment to other jurors in the jury room. Oh, God. Don't do that. The trial judge dismissed the offending juror, but determined that the mistrial was not warranted because it was not relevant to the issue in the guilt phase of the trial and because no other juror had been exposed to the contents of the pamphlet. I mean, they weren't at the sentencing phase yet. But you don't need a juror proselytizing to the other jurors that capital punishment is bad in the middle of a capital punishment case. Don't do that. The Supreme Court affirmed Justice Finnery and Justice Toll dissenting. This is a South Carolina case. The judge that's hearing this case dissented, arguing the inappropriate possession and use of the extraneous pamphlet by jury members so tainted the jury that its contents affected the ability of the jury to be fair and impartial at both the guilt and penalty phases of appellant's bifurcated trial. Oh, that's interesting. Chat, tell me why that's so interesting. That's so interesting. So this is a South Carolina Supreme Court case wherein Justice Toll, the one who's overseeing this case, didn't agree and thought that that was enough. The juror possessing the thing was enough for it to be a mistrial, and didn't agree that the juror possessing the thing but not exposing it to other jurors was not enough. So Justice Toll's already indicating in this case that even though no other juror had been exposed to the contents, that Justice Toll saw that as inappropriate possession and use of an extraneous pamphlet, and that needed to be a mistrial. So Justice Toll already was willing to grant the mistrial in that case when one juror had outside information. That juror was dismissed. No other juror saw it. And this judge was like, no, bet, mistrial. Hey. Dr. Barista is here. Yes. Will you please put 6.5 ounces of coffee into this cup as is? Do not empty it. It still has some of my zhuzh. Okay. Not 8. 6.5. How do I know what 6. Do I have to change? You have to change it on the dial on the top. That sounds so complicated. It's not complicated. You just have to change it. Dr. B, 6.5. You have 17 degrees. When it says 8 ounces of coffee, you got to turn the dial down to 6.5 into this cup. One little. Okay. Thank you. Do you want foam? No, just put it in there. Just coffee? Yep. Coffee and 1 dash of yes. Syrup. Thank you. Got it. Chad is like, it is complicated. Chad agrees with you that it's complicated, Dr. B. Thanks, Dr. B. So Justice Toll was already ready to yeet this case, a different case, back in 1998. So we see that Justice Toll might already lean towards, no, we're not gonna do this. Which is an interesting thing to know because this is the judge hearing this. And that's a case, would I grant a mistrial? I would kick the juror off, but if none of the other jurors had seen it, I don't think I would mistrial an entire case over that, especially a capital case. I'd be like, none of the other jurors saw it. I think I would have gone with the majority on this one, knowing nothing other than what's cited here. I would dismiss the offending juror. I would not grant a mistrial because if none of the other jurors saw it, what's there to mistry? So, Justice Toll didn't agree. Regardless, as in the Holmes case, it provides the controlling legal standard quoted in Cameron. Here, there is more than juror misconduct in reading forbidden matter, which is external material. There was a private communication of a court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. I'm very curious to see if Justice Toll is going to be like, agreed. Because just tell me how you guys feel. Just like sniff test, right? If it is proven that the clerk of court talked to the jurors about any substantive matter beyond lunch, right? Beyond parking. Is the appearance of impropriety such that you had, that was fast.
8 would have taken it to the top.
No, I didn't want 8.
Are you afraid what happened if you had 8?
I wanted 6.5. It's the perfect amount of coffee.
Tolerate that much caffeine.
Thank you.
I didn't taste it, so it tastes fine.
Appreciate it. No, it's going to be great. Appreciate it. So if there's any substantive communication, is the appearance of impropriety such that it has to be a new trial because it doesn't pass the sniff test? Like, this is the type of, Sean said, Emily, I read that the rest of the jury didn't see the content of the pamphlet, but did see the title, and his opinion was that the front of the pamphlet was enough to bias the jury, which would make sense. Even if they didn't read the material, if they saw the material, that could make sense. Here's the thing. When the government, and Courthouse Becky is a wing of the government, the prosecution is an arm of the government. When government officials are fucking around and prosecuting people, I think the appearance of overreaching and impropriety can be such that the judge isn't going to want to mess with it. So if it's proven that there were communications of a substantive nature, it's going to be a huge problem because everyone deserves a fair trial. And if you have different branches of the government messing around with a trial, it absolutely undermines the propriety of the system. and impedes on the defendant's constitutional rights. And then costs the fine people of South Carolina a ton of fucking money. A ton of money. Regardless, as in the Holmes case that provides the more controlling standard, the communication, we read that. When there has been such a communication, a new trial must be granted unless it clearly appears the subject matter of the communication was harmless. So the defense is arguing, again, the standard needs to be the content of the communication. If the communication was, do you guys need a smoke break? Harmless. If the communication was, don't believe Alec Murdaugh, he's lying to y'all. Problem. Again, the state is going to rebut that. Chat's like, will you cover it again? Oh, we're riding this to the end. Like, we have gotten on this roller coaster and we are now on it till we're back at the station. Like, we're with Murdaugh until this case is closed. Like, there's no getting off this ride in the middle. We're on. We're buckled in. They've already like pulled the little bar thing to see if we're secure. We're in. We're riding. We're riding this till it's done. I can't look away. Smith v. Phillips. This is a case cited by the state. This case says nothing about the standard for granting a new trial when a state official tampers with the jury. In Smith, the prosecution failed to disclose that a juror had, during trial, applied for employment as an investigator at the prosecutor's office. Why would you do that? The U.S. Supreme Court held, this court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias, which is what just happened in the Maya case. And bias was not proven. Impropriety was not proven. And agreed with state courts and federal district court that no actual bias was proven. Again, this supports the state's argument that it's not the subject of the communication, it's whether the communication impacted the jurors. So the defense is arguing that the state's case law does not support its position. The applicable standard of proof is a preponderance of the evidence. That is a low standard. As the movement, Mr. Murdaugh has the burden of proving his claim for relief, although no South Carolina case states the standard of proof applicable in this situation. The general rule for new trial motions based on unauthorized communications with jurors is that the standard of proof is a preponderance of the evidence. Mr. Murdaugh must make two showings by a preponderance of the evidence. One, that the contact or communications between the jurors and unauthorized persons occurred. Two, the contact pertained to the matter before the jury. So the defense is arguing that's the standard. Did it happen? Was it substantive? The court must hold an evidentiary hearing, and it seems the court is going to. The court has set aside the dates. I really thought the court needed another hearing to determine whether or not there would be an evidentiary hearing. I saw this as like a two-prong analysis. The first prong of the analysis being, is there going to be a hearing? The second prong being, did the hearing prove the thing? I didn't think we were going to get to, there's going to be a hearing. But the court has set aside a hearing. So it seems that the court has already determined, there's no ruling on the matter, but it seems the court has already determined that a hearing needs to happen. I thought there would be a finding first, an argument over if a hearing needed to happen. The court must hold an evidentiary hearing. The state's response argues that Murdaugh has failed to show that he is entitled to an evidentiary hearing. The court appears to have rejected that argument already because it has set dates for the evidentiary hearing. I am so confused by this. In both Maxwell and Maya, there was litigation, motion, and argument over whether or not a hearing would occur. And in this case, it just seems as a judge like, obviously we need a hearing, and has already set the date for it, but has not made that ruling. I didn't think you just got an evidentiary hearing. Normally that needs to be proven. So, okay. Nevertheless, because the state made the argument, Murdaugh will briefly rebut it, even though the court seems to have already been like, no, we're good. As the state correctly argued before the Court of Appeals, the standard to suspend the direct appeal for leave to file a motion for appeal for a motion for new trial is a prima facie showing of entitlement of relief. That's fine. That's already been done. There has been no material change of the law or to the record before the court other than the discovery of yet more examples of Ms. Hill's dishonesty and malfeasance in office since the Court of Appeals order. It is therefore the law of the case that a prima facie case has been made for the new trial motion. Where the prima facie case is made, an evidentiary hearing is required. So the defense is saying, well, you found that we're entitled to a hearing on a motion for new trial. Therefore, we have to have the evidentiary hearing. And they're citing Barnes v. Joyner. When the defendant presents a credible allegation of communications or contact between a third party and the juror concerning the matter pending before the jury, the defendant has an entitlement to an evidentiary hearing. Look, the state essentially said, we might need an evidentiary hearing. I think everybody knew that an evidentiary hearing was going to happen. The court just hadn't ruled on it yet. In its response to the motion for new trial, the state moves to strike 1, the affidavits of paralegal Holly Miller; 2, any statements regarding jury deliberations; 3, any claims regarding Facebook posts, Ms. Hill's book deal, or post-trial media interactions. It's unclear what purpose striking anything from a motion for new trial would accomplish, given that it's the law of the case that a prima facie case has been made, that an evidentiary hearing therefore is required, and that an evidentiary hearing has been scheduled, and that the motion will be decided on the evidence presented to the court at the hearing and not on an attorney argument made before the court receives any evidence whatsoever. Nevertheless, since the state makes the argument, Mr. Murdaugh will briefly rebut it. They're like, Your Honor, arguendo, we would like to tell the state they are wrong. More. First, the affidavits of Holly Miller are hearsay. Are hearsay. Are hearsay. First, the affidavits of Holly Miller were offered only as evidence to what certain jurors would say if called to testify. Of course, they are hearsay. All affidavits from a person who have not yet testified in court are hearsay. No. Rule 8R1, hearsay is a statement other than one made by a declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. The signed affidavits that are firsthand are, they're not cross-examined, but okay. Hearsay is just an objection to the admissibility of evidence. It's not a basis for striking a filing. I'm not even going to argue with this point. The purpose of Ms. Miller's affidavit was to help obtain an evidentiary hearing, which has been accomplished. Obviously, they cannot prove Murdaugh is entitled to a new trial. Witness testimony in a courtroom will do that. I agree with that. Second, there is no basis for the state's motion to strike references to jury deliberations. You can't ask about jury deliberations. Juror 630's affidavit was freely given to support a public filing. But you can't inquire about it. Other jurors have spoken about the deliberations in national television interviews, but it can't be inquired about on the hearing for new trial at all. Such statements may or may not be admissible as evidence. No, they're not. We'll just clear that up. They're not at the merits of the evidentiary hearing, but Rule 606 and the South Carolina Rules of Evidence in no way supports striking public statements from a motion memorandum. Third, the state correctly notes that the only reference of the Facebook post Ms. Hill fabricated to remove Juror 785, her book plans, and her other post-trial actions is to impeach Ms. Hill. The state argues attacking Ms. Hill's character is an outlandish theory. That aged well. The prosecutors are like, well, y'all, we might have backed the wrong horse on this one. The admissions of plagiarism and the son's arrest for wire tampering is pretty far removed from this, but her cell phone being taken by search warrant in connection with the wiretapping also doesn't bode well. And when you're talking about attacking Ms. Hill's character, the plagiarism is going to come up and the state ethics complaints are going to come up, and the ethics complaints alleging that she was improperly taking money and other things are all going to come up. The ethics investigations are going to come up because her character is the crux of the thing. Because if the juror said she said it and she said I didn't, what do you lean into except for character? The state argues attacking Miss Hill's character is an outlandish theory. What say you now against a dedicated public servant that is immaterial, impertinent, and scandalous, and so should be struck? This didn't age well. This did not age well. Okay. I found the plagiarism pretty scandalous. The defense says that is incorrect. Miss Hill likely is the only witness the state can offer who can directly contradict Juror 630's averments of jury tampering. And Miss Hill has offered an affidavit doing exactly that. She has. Miss Hill offered an affidavit saying that this is not true. Her credibility is the crux of the matter before the court. I agree. The purpose of an evidentiary hearing is to allow the court to decide whether it believes the word of Miss Hill more than it believes the sworn testimony of one or more jurors, depending on what the jurors say. Anything that impeaches Miss Hill is relevant. It might not be admissible, but yes, it's relevant. And the state's rhetoric about Miss Hill being a, quote, dedicated public servant, a dedicated public servant, has aged like milk. And the state's, look, there are times that Putin company annoy the fuck out of me, but I'm not annoyed by this at all. They're not wrong. Look, they're not wrong. Whether you like these attorneys or not, this argument is not wrong. And the state's rhetoric about Miss Hill being a dedicated public servant unfairly maligned has not aged well in the 2 months since the state filed its response, to put it mildly. I mean, that's just a fact. It's gotten so fucking bad. So whether you love Dick and Jim and team, hate Dick and Jim and team, are neutral to them, they're not wrong. That's not wrong. It's just not wrong. Two things can be true at once. Miss Hill is alleged to have stolen money, illegally sold access to the courthouse, conspired with her son to conduct illegal wiretaps, and even had her book removed from publication because of her plagiarism. Yeah. This is not going to go well. This is not going to go well. To prevail, Mr. Murdaugh must prove by a preponderance of the evidence that Miss Hill made statements to at least one deliberating juror about the merits of the evidence presented at trial. The issue presented to the court is not what happened during jury deliberations. I agree. You can't get into that. It's what happened during the presentation of evidence at the trial. Murdaugh anticipates at least one deliberating juror will testify that Hill advocated against Mr. Murdaugh in improper communications to jurors during the trial, and at least two other persons who were part of the jury at the time will corroborate that testimony. Such communications include telling jurors not to be, quote, misled by evidence presented in Mr. Murdaugh's defense. You can't do that. Not to be fooled by Mr. Murdaugh's testimony in his own defense. Based on the chart of juror interviews provided in the state's response, at least 5 jurors, including the dismissed juror and an alternate, will testify that Hill told jurors to watch Mr. Murdaugh's body language when he testified. You can't talk to them about substance at all. Christina said, I missed the plagiarism. She didn't even write the book. She did write the book. We'll talk about the plagiarism later. The forward of the book, not the forward, the introduction. Hold on. The preface. This is why I bought. This is evidence, people. I didn't want to support this fuckery, but we needed a copy for evidence. The preface is directly written from a BBC article that was accidentally emailed to Becky Hill. Like, she changed the spelling of some of the words because not in Europe, but it is plagiarized from a BBC article, and she admitted such and apologized. She whoopsie doodled. We'll get there. Mr. Murdaugh also anticipates juror testimony that Ms. Hill asked jurors for their opinions about Murdaugh's guilt or innocence. She did that in her emails. She was asking people that were emailing her that she pressured jurors to reach a quick verdict. She was telling reporters in the emails, and I'm not done with all the emails, but in the emails I've seen, she was telling reporters should be like a 30-minute verdict. That's in her email. Telling them from the outset of, this is why I read the emails, telling them from the outset of their deliberations that it shouldn't take them long and that she had frequent private conversations with the jury, foreperson, who was picked by Judge Newman. The jurors had determined their own foreperson, and then Judge Newman, do you remember this day in court? I was so confused. Judge Newman's like, I know y'all picked your own foreperson, but that's not how we do it. We're picking one. It was weird. It is likely several jurors that will testify that they never had any such jury tampering and that they do not believe it occurred. But that is not a direct contradiction of the testimony of the jurors who say they saw and heard it. Mr. Murdaugh anticipates the only person who can directly contradict jurors who witnessed Ms. Hill's jury tampering is Ms. Hill. Mr. Murdaugh therefore must present evidence corroborating juror 630's testimony, including testimony from the alternate juror and juror 785 who was dismissed on the last day of trial, and possibly testimony from court staff. He must also present evidence impeaching Ms. Hill. Evidence impeaching Ms. Hill includes hold on. I feel like we need a music bed for this. Why? Because I feel like we do. Because I feel like we're in like the Twilight Zone. Thanks, StreamYard. I feel like we needed background music for this. Evidence, because it's such a fucking shit show at this point. Evidence impeaching Ms. Hill includes her emails, text messages, and telephone records, testimony from court staff, testimony and documentary evidence from persons involved in the production of her book, complaints against Ms. Hill, and the results of the investigations into Ms. Hill's wrongdoing. This includes evidence related to her involvement in the removal of juror 785, not because the removal itself is grounds for a new trial, but because juror 785 has averred Ms. Hill was involved with her removal in an improper and dishonest way that, if true, would serve to impeach Ms. Hill's credibility. Both witnesses and documentary evidence regarding the alleged fabricated Facebook post, which ultimately did not cause juror 785 to be removed, and witnesses and documentary evidence regarding juror 785's allegations, alleged statements to her tenants during trial, which ultimately did cause the juror to be removed, are relevant to Hill's credibility. So they're not saying we're going to relitigate the Facebook post. We're saying if Ms. Hill did this, she's still messing with the jury. Evidence impeaching Ms. Hill includes evidence demonstrating her personal interest in the outcome of the trial and willingness to engage in obviously inappropriate conduct to further that personal interest. For example, emails released to journalists in response to a FOIA request show that Ms. Hill was sending emails directly to prosecutors and law enforcement witnesses for the state during trial about the merits of testimony from defense witnesses under examination at that moment. This is so not okay. It's so not okay. And we're going to get into that. Email, because they're attached. Emails from Becky Hill to Creighton Waters, C. Jewel, and C. Gent, February 21st, 2023. Attached as Exhibit A. Evidence impeaching Ms. Hill likely also includes testimony from Judge Newman. That'd be wild. That'll be wild. It is possible that Hill will respond to one or more questions at the evidentiary hearing by asserting rights under the Fifth Amendment. You think? You think? You think Becky Hill's going to be like, so jury tampering's a crime. I can't just talk to you about this. Guess she can write a book about how she ruined the biggest trial of the century. Maybe. I still don't think it's the trial of the century. She was emailing prosecutors. Roy, we're going to get to that. She was mostly forwarding emails, but still. Becky Hill should not be permitted to plead the Fifth, is what the defense is saying. She waived the right to assert the Fifth Amendment in this proceeding when she submitted an affidavit specifically denying each allegation against her. Well, I don't know if that's true. I think they can strike the affidavit and then there would be no statement from Becky Hill. I don't think they can deny her the right to plead the fifth. I think they would strike the affidavit, so the affidavit can't be used. C. Brown versus United States, 1958, holding that if a witness offers testimony voluntarily, his credibility may be impeached and his testimony assailed like that of any other witness, and the breadth of his waiver is determined by the scope of relevant cross-examination. If she asserts the Fifth Amendment in response to any question, she should be instructed to answer the question, and if she refuses, her testimony should be struck in its entirety. I think you can strike the affidavit. There will be much evidence to present that impeaches Ms. Hill. The state may argue presenting it all would be cumulative or repetitive or otherwise unnecessary, but evidence is cumulative only when it supports a fact established by the existing evidence. Evidence, Black's Law's Dictionary. Thanks for that. So long as the court is prepared to give Ms. Hill's testimony any weight, her lack of credibility is not established, and evidence impeaching her cannot be considered cumulative or repetitive. You can basically feel them like, please let us bring everything in. We never have this much evidence. We're defense attorneys. Please let us do all of the things. You can feel it. You can feel them waiting to bring in days worth of evidence against Ms. Hill. Do I think Poot and Jim are going to try to bury Ms. Hill? Yes. Is that their job? Yes. Steve C. asks, who will Becky get to defend her? Right now, Becky's attorney is Justin Bamberg. So that's who. And he's the one that released a statement apologizing for her plagiarism. So you guys all saw him speak at the sentencing because he also represents some of the Murdaugh victims. Let's go to footnote 1. If the court were to decide pre-hearing that it cannot credit Ms. Hill over the sworn testimony of any juror, it is likely that a hearing would consist only of court-conducted in-camera examination of the jurors. This would also avoid potential Fifth Amendment issues regarding Ms. Hill. It is unlikely the state would agree to this, since it's likely the state can prevail only if the court finds Ms. Hill to be credible. Courts have underscored the non-cumulative nature of additional evidence when a trial features a quote-unquote swearing match between witnesses on both sides. They said. Like each one swears they're telling the truth. There's lots of case law backing that up. Currently, defense counsel anticipates identifying the trial transcript and exhibits from the trial for use at the evidentiary hearing. However, until such a time as the state provides Mr. Murdaugh with its discovery in this matter, his counsel is unable to provide the court with a complete list of exhibitees and witnesses or a list of subpoenas he needs. Once the state produces its discovery, defense counsel will supplement this response immediately to provide a complete list. That's not been supplemented as of last night, including a list of subpoenas he needs, if any are needed. It is likely much of the information he would otherwise seek by subpoena has already been compiled by the state. To the extent more subpoenas are needed, it would expedite the process if the court were to authorize Murdaugh's counsel to issue subpoenas before the evidentiary hearing, depending on the recipient. Mr. Murdaugh at present does not anticipate requesting a subpoena for documentary discovery regarding any deliberating juror, but cannot be certain before receiving discovery from the state. The state has had months in which to use the tools available to law enforcement to conduct discovery regarding this motion, as well as to investigate the numerous independent complaints of wrongdoing against Hill. It will be well prepared to bolster its witnesses and to impeach witnesses favorable to the defense. Murdaugh will be unable to conduct any discovery whatsoever. All he has are voluntary statements made by jurors and other witnesses willing to talk to his lawyers and information published by journalists. To be prepared to go forward on the January 29th date set for the evidentiary hearing, he urgently needs the state to produce discovery and to receive authorization to issue his own subpoenas. Jurors and Judge Newman, if necessary, should be examined in camera by the court, but other witnesses should be examined in open court. So they're talking about the jurors not being examined on the witness stand. In other cases, when jurors have been examined, they've been examined in open court. Let's see. All witnesses should be so examined unless there's good cause to reserve examination to the court. Mr. Murdaugh believes good cause exists for the court to conduct the examination of jurors, including the dismissed juror and alternate juror, in camera. That would be in chambers. There would be a transcript of it, but it wouldn't be on the it wouldn't be televised. It wouldn't be in open court. Even reporters sitting in court, I mean, they'd see the juror walking in and out, but they wouldn't see the juror's testimony. In addition, from shielding jurors from appearing on television involuntarily, in-camera examination is necessary because it will be difficult for a juror to testify without revealing personal identifying information like his or her name and the names of other jurors. By testifying in camera, jurors may speak freely. Other courts have just done this publicly. Further, jurors may be unsettled by being interrogated by the same lawyers they watched interrogate witnesses for 6 weeks. Examination by the court avoids that issue. I think in all cases, the case law establishes that when questioning a juror, the judge does the questioning. And that should be the way that it is. I absolutely agree that that should be the way that it is. The state agrees jurors should be examined by the court and has argued the court should question them with a mind to at least whether the communication occurred, if so, the context and substance. Yes. Did the clerk of court speak to you? Yes. Did the clerk of court speak to you about Mr. Murdaugh? Yes. What was said to the best of your memory? 2, the number of jurors exposed to the improper communication. Who else was there? 3, the weight of the evidence properly before the jury. No. No. Absolutely not. Absolutely not. No. You've lost me at number 3. That gets into how the jurors deliberated the case. No way. The first 2, yes. 4, the likelihood that curative measures were effective in reducing prejudice. I don't know if you need to get to that at all. Only the first topic is appropriate. No, the first 2 topics are appropriate. This was what the state says should be questioned. I think the first 2 are appropriate. The only subject for juror examinations is whether Ms. Hill made improper communications on the merits of the case, including anything serving to corroborate and refute the testimony. Yeah. The number of jurors exposed to the communications is irrelevant so long as it is at least one deliberating juror. I don't think it's irrelevant. The weight of the evidence properly before the jury and the likelihood that curative measures were effective in reducing the prejudice is irrelevant. I don't disagree. If testimony is needed from Judge Newman, Mr. Murdaugh believes it should also be conducted in camera to preserve the dignity of his judicial office. Mr. Murdaugh does not believe good cause exists to examine any other witnesses, including Ms. Hill, in any fashion other than the traditional means of an attorney questioning in open court. They should all be, this whole thing should be questioning by the court. This whole evidentiary hearing. Dreamscape asks a great question in the chat. Lawyers are present at an in-camera questioning. Yes, they are. But they're not participating. They're observing. There would also be a court reporter. Let's see. They want the attorneys to question Hill in open court. I think the court should do that. Hill is an elected official accused of malfeasance in office, whom Mr. Murdaugh has accused of violating its constitutional rights in a criminal proceeding, and who has voluntarily provided an affidavit directly contradicting Mr. Murdaugh's claims. She does not need to be shielded from scrutiny in the same manner as anonymous jurors involuntarily summoned to serve. She is a witness against Mr. Murdaugh in a criminal case, whom Mr. Murdaugh has a right to challenge in open court. Footnote 2. And this gets into the right of confrontation and cross-examination. Counsel for non-parties should not be permitted to participate in these proceedings. Oh boy. Oh boy. Oh boy. Oh boy. The fighting in this case online has been interesting to see. But the fighting between like Eric Bland and others is just, it's gotten strange, y'all. It's weird for me to watch all of the fighting that's like tangential. There's like internet drama now surrounding this case. But they fucking hate Eric Bland. It's just, there's so much drama. And they wanted to make sure, my opinion, they wanted to make sure that the judge knew this. So all of this, do I think any of this is relevant? No. Do I think they wanted to make sure to throw Eric Bland under the bus? Yes. You guys tell me how you feel about it. Let's go through it. Attorney Eric Bland is requested to participate in these proceedings as counsel for certain jurors who may be called to testify. I have not seen a motion to that effect. New TV on Bravo, The Real Lawyers of South Carolina. Oh my God. Put them all in confessionals. Put them all in confessionals. You can leave. Bring Meredith in. Meredith's a lawyer. Bring Meredith in. There is so much drama. Teresa asked something completely off topic that totally caught my eye because yes. Have you seen where Giselle and Robin are in a trademark case with Eminem over the word shady? Yes, it's on my docket. Like it's on my radar over the Reasonably Shady podcast. It's absolutely on my radar. Let's talk about the Eric Bland drama, shall we? I should have swooped. Drama. Let's talk about drama. I've not seen a motion where Eric Bland has asked to participate. I've heard him talk about it on their podcast. Mr. Murdaugh objects to Mr. Bland's request. This is a criminal proceeding brought by the state against the defendant. Mr. Bland seeks a level of non-party participation, e.g. participating in a status conference, beyond even the rights afforded to victims under Article 1, Section 24 of the South Carolina Constitution, and the jurors he represents are not crime victims. In discussing his request to the media, Mr. Bland stated on his podcast, Cup of Justice, episode 61, December 26, that Judge Toll, the newly assigned presiding judge in this matter, quote, has friends sometimes to reward and enemies to punish. I listened to that podcast, absolutely said it. Let me know your thoughts on that. I was surprised listening to the podcast. I was surprised. Because I can understand talking about a judge and being like, I don't like this judge's temperament. There is a judge who I still check for their obituary because just evil sometimes doesn't need to be in the world. But this judge and I did not get along. But what I would say about that is this judge and I do not get along, and I will not hear a case in their courtroom. I have seen them be perfectly fair to other attorneys. I have seen them do this and do that. But implying that a judge is rewarding friends and punishing enemies indicates that the bench officer is doing something improper, that there is a bias there and an impropriety there, and that bias and impropriety is that the judge will change the way that they're ruling based on who the lawyers are. And I don't think that statement is going to go well. I was surprised to hear it. He is still a practicing attorney in this jurisdiction. He's practiced before this judge. This judge has ruled against him. Though that might be your opinion, saying it in a public forum where you're talking about this judge being assigned to the case could be a problem. So it implies that the judge is ruling based on who the lawyers are and not the merits of the case, which is implying judicial impropriety, which is, I think, a problem. It goes on to say, I worry about what procedures are going to be put in place. The fact that there was a status conference and I represent 4 jurors and I wasn't even told of the status conference, and I believe that my jurors have the right to legal representation in any type of proceeding dealing with Alex Murdaugh's verdicts where they're going to have their verdicts questioned. I don't think there's anything improper about that. He's indicating, I want to be kept in the loop. I don't know if he has a right to be kept in the loop until those jurors are subpoenaed. Once those jurors are subpoenaed, he has a right to be kept in the loop. Does he have a right to be kept in the loop before that? No. His stated intent is not to protect the personal interests of his clients as witnesses, but to advocate to sustain their verdict. To allow a publicity-seeking lawyer, sir, who signed this? Which one of the teams signed this? Come on now. the shade to allow a publicity-seeking lawyer for non-victim private parties to intervene in this criminal case and advocate against Mr. Murdaugh as an additional opposing party would violate Murdaugh's procedural due process rights under Article 3 of the Constitution. I have not seen any motion where Eric Bland has sought to intervene in this case. He made a statement on a podcast that he was annoyed that he didn't know there was a status conference. He has not filed any motions. He has not done anything to try to intervene or intercede. If his clients are subpoenaed, then he can respond to it. But Lucy makes a great point. Which attorney has the podcast? Eric Bland and Jim Griffin. Jim Griffin also has a podcast. The fact that these lawyers are like, this publicity-seeking lawyer, like, just stop it. Because wasn't Jim Griffin in the first HBO documentary and then a subsequent one? Like, all of them have been involved. Like, it's not like they're sitting back there being like, oh no, don't put me on TV. They're like, did you get my good side? Am I allowed to say that? Stop. But this part seems to indicate to me, because Eric Bland has not tried to intercede. He made a comment on a podcast. They want to throw him the fuck under the bus by letting the judge know that Eric Bland made this statement about the judge publicly. That is the entire point of all of this. They want Judge Toll to know Eric Bland said that you have friends to reward and enemies to punish. That's what they wanted to do. Putin Jim did all the press conference, all of them. And CrimeCon. Yep. They all want attention. Yep. Which is why it's so funny to watch them being like, they want attention. All of you are begging for attention all of the time, says the content creator. It's just wild. So again, all of them, they're just like pot kettle at this point. But they wanted to tattle to the judge and they wanted to call him out in a public way. And they did. That's exactly what this is. Isn't any of this relevant to the case? No, he hasn't asked to intercede. So there's that. But it is absolutely, Eric said that on the podcast. If you want to go listen, it's the December episode 61. It's in there. That statement might have some problems for Eric Bland, but that's not for Poot at all. That's for the judge. They all want attention. Trial lawyers always want attention. Trial lawyers like being the center of this show. They like being like, they're all eyes on me in the center of a ring, just like a circus. Like, it's not a surprise that trial lawyers are like, sit there, don't talk for 6 weeks and look at me. Like, it's not, trial lawyers tend to not be shy. They want to be on stage. If trial lawyers didn't want to be on stage, they wouldn't be trial lawyers. They would be like the coroners of lawyers. They would go do like intellectual property law or patents and trademarks and stuff. They would go do paper law where they never have to talk to people. They would go do something else. The attention-seeking ones want to be trial lawyers. They're like, let me convince you. It's very Chicago. Anyway, I think that I wonder if they're just mad that Cup of Justice is a more successful podcast than, what is Jim Griffin's podcast? Can you tell me? I don't know. I don't know the name of it. Then whatever Jim Griffin's podcast is. Are they all just fighting over whose podcast is better? Mine. Listen to the Emily Show. The war of the podcast. Do you know who else has a podcast? Every single member of every single reality cast. Every single one. Every single one has a podcast. Rachel Raquel has dropped a podcast. Katie is dropping a podcast. All the like, why is it the year of the podcast? I've had my podcast for 4 years. Just saying. The jurors are simply witnesses with no more right to participate in this criminal proceeding than witnesses in any other case. Unlike typical witnesses, they do have a right to a degree of anonymity, so it could be appropriate to allow them to be heard through counsel if the court were inclined to strip them of if the court were inclined to strip them of that anonymity, but neither party is asking the court to do that. The court has made clear that it's not inclined to do that. Mr. Murdaugh does not seek to subpoena telephone records or other personal records regarding them. Yep. And if he decides to do so in the future, their lawyers, of course, could make a motion to quash. The reason to hold an evidentiary hearing on defendant's motion for new trial is to protect Mr. Murdaugh's constitutional right to a fair trial. Yes. Yes, it is. It would defeat that purpose. It would defeat that purpose if the proceedings were allowed to devolve into a speaker's quarter for lawyers who want to appear on television even more than they already do. Okay. Murdaugh therefore asked the court to limit the participation of any witness retained lawyer to the extremely limited role traditionally allowed to a lawyer representing an innocent bystander witness in a criminal case. There is no role for other lawyers in this case. If your client is subpoenaed, then there's a role. If your client's not subpoenaed, then there is no role. It's very hard to give up control and allow this proceeding to happen. I think the judge has been transparent. All the filings have been made public and easily accessible. The scheduling order is accessible. All of this has been, I think, fairly transparent. The only thing I'm annoyed about is the way that they've done the media order, but that's on me, and I'll deal with it. So, oh man. For the foregoing reasons, Murdaugh respectfully submits that when Ms. Hill's jury tampering is proven at the evidentiary hearing, the court must grant the motion for new trial. If Ms. Hill's jury tampering is proven, then yes, that is the correct result. There's no other correct result. If the clerk of court tampered with the jury, then yes. And there also probably should be a prosecution because jury tampering is a crime. But we have to see what's proven. Exhibit A. Emails from Becky Hill. Becky Hill, website Murdaugh Trial 2, Creighton Waters. This is from this individual. For Creighton Waters, forensic research witness is ignoring the standard crouching/stalking posture of a 6'3" person would use to quietly approach the target. His assumption assumes someone simply walking up to a target to shoot on cross. Ask what height the 300 blackout would be if stalking a target. Look, there's more of these. I'm going to go through all of them and then tell you what I think. So this is forwarded on February 21st at 13:44. This came into the website at 1 p.m. on February 21st, the day of this testimony, presumably. This is another one forwarded on the 21st. Becky Hill said, here's another one. Website inquiry, defense witness Mike Sutton. Defense witness Mike Sutton. I'm a former paratrooper, qualified U.S. Army veteran, and left the service at the rank of captain. I regularly shoot AR-15 style rifles and have assembled them, built them, changed barrels, calibers, handguns, and components. I'm very familiar with both the weapon platform as well as ballistics. Okay. This witness's testimony that the shooter had to be 5'2" to 5'4" is frankly pathetic. I mean, the prosecution already did that. His projections rely solely on the assumption that the shooter was standing upright when shooting. He ignores the probability that the shooter was either on one knee or standing, but in a crouch. This all came up on cross-examination. It's very likely an attacker would have been crouching low to conceal their presence, at least at the start of the killings. He ignores that the rifle could have anywhere from a 7 foot to 20 or 7 foot, Jesus Christ, a 7-inch to 24-inch barrel. Emily. And if it was outfitted with a collapsible stock, all of his assumptions would have to change. I hope you're able to rebut the assertions as I find them laughable. So there were a lot of these things that came in through the court website. The problem is not that these came in. Look, in Beckaboo's emails, there was a lot of stuff from the public that was just wild. As the public does. When I cover cases, I get emails like that too. There are emails to me that are like, Emily, you're missing this larger conspiracy theory. And I'm like, okay. you will get public emails like this. There were numerous public emails like this with all kinds of statements. There was one that was like, watch this video because Murdaugh was passed something by his lawyers. And there was like, why is, you need to watch the gallery better because Buster made a gesture at the judge. There was all of these other emails that came in from the public. These emails that said they were for Creighton Waters, she forwarded them to Creighton Waters. And these came in through the website. So you can see that these messages are from no reply at Jot form. So these are from a website inquiry form on the Colton County website. Here's the thing. I have never seen a clerk of court forward things just to one side. If they're going to be forwarded, either you respond with Mr. Waters' email is this and tell them where to redirect the email. You don't respond at all. You email it to all sides. And I wouldn't even think a clerk of court would email it to all sides without asking the judge. Or you ask the judge and say, Your Honor, do you want me to ignore these or email them to all sides? Yes, Lyndon, forward and CC to literally everyone if you send anywhere. Right. Or send it nowhere. But she would have needed to have had this conversation with the judge. Hey, we're getting these inquiries from the public. Do you want us to respond at all? Because I'm sure the email was getting hit quite a lot. And we only see the responses. We don't see all the inbound emails in the FOIA dump. We see her outbound emails. But they should have had that conversation with the judge. Do you want them to be forwarded to everyone, ignored, forwarded after the trial? Do you want us to respond just giving the email to the proper person? But I'm sure these public inquiries not only went to the court website, but if the public is publicing properly, these probably went to all of Creighton Waters' emails. They're all on the state AG's website. I think people also went through the court thinking they would get this information to Creighton Waters sooner. I imagine that Creighton Waters didn't see any of these emails until later because I imagine the trial team wasn't checking their email because what they don't need is input from anybody else. And anyone's input that they need is going to be texted to them from their internal team. What you don't need is the public weighing in on how you're doing your cross-examination. It will throw you off your game. So I imagine they weren't even checking their emails in this way until later. But don't forward them to Creighton. So I wonder, because in this email dump, there were quite a lot of emails from reporters as well. I don't know how annoyed they are, but the reporters' email addresses are in there, like business and sometimes personal emails. Their phone numbers are in there, and I don't know if they have separate phone numbers or not. So in this email dump that has been made public, there's quite a lot of information, which is why I haven't just pulled it up and gone through it because I'm still going through redacting some of it myself before I pull it up on the internet. Because there's quite a lot of information in there that's just. Ugh. Jordan asks, is this illegal or just cringy? I don't think it's illegal to forward an email, but does it show potential impropriety or bias? Maybe. Should the clerk of court have been forwarding this to just one side? No, I don't. I don't think it should be at all. Let's go to the state's response. I know Eric Bland responded to some of this on Twitter. I don't know if his law firm put out a statement, but I think some of this was responded to on Twitter. Maybe we'll do that. But Lucy said might not be illegal, feels unethical. Absolutely feels unethical. And it gives it when you start looking at the emails and you see her leaning towards guilt clearly in the emails, which again, she's allowed to do. She's the clerk of court. You're not allowed to communicate that to the jury. But showing that you are involving yourself in the case by forwarding information to Creighton Waters is a problem instead of putting it out through to everybody. it's just, it's not good. Question, has someone ever worked at a courtroom, wrote a book that messed up a trial? I mean, we might be watching that unfold. The jury has grown up and made their decisions. She did not twist their arms for their guilty votes. It might not matter if she did or if she didn't. If she talked to them improperly, it might be enough. I thought the trial had a media public relations attorney. It did. It absolutely did. Absolutely did. It's the appearance of impropriety, in addition to everything else, is not going to be helpful. All right, let's get to the state's response to this. Let's see. That's the defense pre-hearing. That's the scheduling order. Where is the state's pre-hearing motion? Where are my notes? Emily! Girl, get it together. I closed out my other notes. Y'all, why is this one of those days? That's the scheduling motion. That's the pre-hearing. Where is my state's pre-hearing? My document is missing, so give me a second to find it because I have it. I just don't see it. So sorry, y'all. No, wrong, bad, Emily. We're gonna take a little stretch break while I find my document that I thought I put in my notes. So sorry, y'all. We're getting back to it. We're trying over here. Where is that? It's in my notes. Good Lord. I just don't see it in my proper Google Drive. All right, y'all. I'm glad we took a little dance break before we get into the state's motion. So the state's, let's go back. Did I talk about the date that the defense one was filed on? We probably need that. So the defense pre-hearing brief was filed on January 3rd. Let's see when it was signed. It was signed by the attorneys on January 3rd. The state's pre-hearing brief is from January 3rd, signed January 3rd. So let me make that the right size. I think we're almost there so you guys can, so nothing gets cut off on the side. I think that's cutting it close, Emily. There we go. Zhuzh it just a little bit. State versus Murdaugh. State's pre-hearing brief in opposition to defense motion for a new trial. Many of the legal and factual issues in contention have been addressed at considerable length by the state and in its response to defendant's motion for new trial and motions to strike filed November 7th. The following is a summary of the various issues the state contends need to be litigated for the motion for new trial. Burden of proof. Murdaugh must carry the burden of proof, both that an improper contact occurred with the jury and that he was actually prejudiced thereby. This is the fight of the entire thing. What is the standard? And do you have to just prove that there was a communication between Becky Hill that was substantive, or do you have to prove that the jury was swayed somehow and he was biased, like that the jury was actually unfair? First is the appropriate burden and standard to apply to a motion for new trial based on allegations of improper contact with a jury by clerk of court or court official. Case law in general respect for the burdens of public service on a jury, particularly in a case as lengthy and complicated as this one, preclude jurors from being subjected to an invasive and burdensome inquiry as if they were themselves charged and on trial. The burden rests with the movant, in this case Murdaugh, to prove that an improper contact occurred between at least one juror who deliberated and a non-juror. And further that he was actually prejudiced by the improper contact. Murdaugh must make a prima facie showing that he can meet the burden before an evidentiary hearing may be granted. And as part of that showing, he must establish he was not contemporaneously aware of the issue alleged and failed to raise it. The court seems to have found that met because the court scheduled a hearing. Murdaugh argues that because he alleges improper contacts by a court official, prejudice must be presumed under the Reamer case, and that the burden of proof thus shifts to the state to prove lack of any prejudice. However, Reamer's, quote, presumption of prejudice standard was abrogated by the standard set in Smith v. Phillips, 1982. The remedy is the opportunity to prove actual bias, and in any event, has also been recently rejected by the Supreme Court of South Carolina in State v. Green. Accordingly, Murdaugh bears the Murdaugh bears the burden to show prejudice. Murdaugh argues that he doesn't have to show prejudice at all. At all. Just the communication occurred. So the court is going to have to lay out first what needs to be proven and then what happens from there, because the sides don't agree. Evidentiary hearing is unnecessary because Murdaugh has failed to make a prima facie showing of prejudice. The court clearly doesn't agree. Indeed, the state's next argument is that no further evidentiary inquiry is necessary, as defendant failed to make a prima facie showing required to necessitate an evidentiary hearing. No. Not a single juror who actually deliberated on the case indicates that their deliberations or verdict was in any way affected by the improper contacts alleged. But there were contacts, though. And I think that requires a hearing. All jurors were polled individually and affirmed their verdicts on the record to the state. But some of them said there were conversations. Murdaugh offers his motion and affidavit from only one juror who deliberated, Juror 630. In the affidavit, Juror 630 attributes statements to Clerk Hill which resemble arguments made by the state, but she does not claim she was influenced by Clerk Hill, but rather merely felt pressure from other jurors. Due process is not implicated by pressure upon one juror by other jurors. No, that's kind of the system. Thus, Juror 630's affidavit is affirmatively inconsistent with the prima facie showing necessary for an evidentiary hearing. Juror 785, the so-called egg juror and landlord to Juror 630, that's so weird, did not participate in deliberations and was removed for her own violations of the court's instructions not to discuss the case with third parties, and a lack of forthcoming candor regarding those discussions. Further, when asked by Judge Newman at trial if Clerk Hill discussed anything about the case with anybody on the jury, Juror 785 replied, "Not that I'm aware of." The affidavits in the defense motion on their own do not support a new trial, and the motion should be denied on the pleadings. I don't think that's going to happen. Moreover, none of the other jurors who deliberated who spoke to SLED after Murdaugh filed his motion, the state's whole response right now is, trust me, bro. And the allegations are so bad that trust me, bro, is not going to be enough. I saw a great question in the chat that I wanted to grab, but I don't know where it went. Shelby, great question. I want to know who paid the juror's salary for 6 weeks and what did he owe in return. The jurors get paid $20 a day from the state. So unless there is information that is not publicly available or not that I have not seen, the jurors were not paid other than their $20 a day that they get paid by the state. Nonetheless, Murdaugh argues that a hearing is necessary seemingly in order to impeach Clerk Hill. Well, to find out if Clerk Hill made these statements, and then if Clerk Hill's like, I didn't say any of that, to be like, did you plagiarize your book though? Because how do we just trust you being like, no, it's cool? Because now your trustworthiness is in question. Valkyrie Arts, $20 a day. $20 a day for jury duty. And they get lunch and parking sometimes too. It's a whole thing. Financial hardship for jurors is a whole situation. But if jurors work for government entities or large corporations, sometimes they are paid by their employer, so that can happen. Nonetheless, Murdaugh argues that a hearing is necessary seemingly in order to impeach Clerk Hill. That a potential witness may be impeachable is inconsequential to whether defendant has made a prima facie showing. I mean, that's true. The jurors found Murdaugh guilty, affirmed their verdict when polled, and none have alleged Clerk Hill influenced them. Thus, no evidentiary hearing is necessary. Again, I thought that you would see the court have a hearing to decide. This sounds so law, that the court would have a hearing to decide if there should be a hearing. That's what we saw in the Maxwell case. We saw lots of briefing on whether a hearing was necessary. And that's what we saw in the Maya case. And that's what we see most of the time. The court determining whether or not you would have a hearing. But it seems that this court has already granted a hearing because the court's already set aside the time for the hearing. And the court hasn't made notice saying, I'm reserving these days for a hearing if needed, which the judge in the Maya case was very careful to do. If a hearing is needed and if a hearing is granted, do these dates work? But it seems that the judge has granted a hearing. But whether a hearing is granted is the first step to this inquiry. And I'm interested to see what happens on the next hearing date, which is what, the 16th, I think? I think that's what I said earlier. The 19th, one of those days. It's next week. Judicially conducted limited questioning. Should the court deem an evidentiary hearing necessary, the procedure should be judicially guided and the scope of relevant evidence limited. Agreed. That's the standard. That's the standard. In the event that the court deems an evidentiary hearing necessary to realize the motion, any inquiry of the jurors would be limited and judicially conducted to minimize intrusion into the lives of those who performed such public service in the case. Assuming the court rules, as argued above, that Murdaugh must show prejudice, the following questions to deliberating jurors based on the record on appeal reflects what the trial used in State v. Green should be sufficient. On March 2nd, did you answer when polled that your verdict was guilty on each charges? Were you instructed to do so by Judge Newman? Was your verdict on March 2nd based solely on the test? I think you need more questions than that. Was your verdict based solely on the testimony, evidence, law, and arguments of counsel as presented at the trial? I think they can ask, did anyone talk to you about the substance of the case? I think there's other questions there. This is sufficient to determine whether there was any improper effect on the verdict and minimize the intrusion on the jury while preserving the facts of the proceeding upon the allegation actually raised by Murdaugh's motion. South Carolina Rules of Evidence 606B make this clear. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations. Yes, you can't get into the sanctity of deliberations. What juror was holding out? What juror persuaded you? What did these jurors say to persuade you? Did you like your lunch? Like, you can't get into that. But you can ask, did the clerk speak to you about the case beyond scheduling and comfort and parking and things? And what was that communication? And did that influence you when you went into the jury room? Those things can be asked. But not what happened once jurors started deliberating. Cannot testify as to any matter or statement occurring during the course of the jury's deliberation or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or dissent from the verdict or indictment or concerning the juror's mental process in connection therewith, except that a juror may testify on the question whether extraneous prejudicial information was improperly brought to the juror's attention or whether any outside influence was improperly brought to bear upon any juror. Nor may any juror's affidavit or evidence of any statement by the juror concerning the matter about which the juror would be precluded from testifying be received for these purposes. This is from the Model Rules of Evidence. So you'll see a version of this in most states. I say most because I haven't looked at the rules of evidence of every state, but in the multiple states I've seen address it, they all have a very similar rule of evidence to this because they all come from the Model Rules of Evidence. In the event any juror answers the above questions raise the need for additional inquiry, then additional inquiry would be warranted with questions from the court, questions suggested to the court by counsel and questioning by counsel, as well as evidence from additional relevant witnesses. The court can ask the lawyers for questions and choose to ask them or not. The lawyers can't inquire of the jurors. Defendant wishes to make the central focus on the credibility of Clerk Hill as a potential witness, specifically the context of Facebook posts supposedly involving juror 785's ex-spouse. Here's the reason why, though. The credibility of Becky Hill is what's really what comes into this. If the jurors say that there was no communication, then it's not relevant. But if the jurors say there was communication, and the communication was by the clerk of court, and the communication was substantive about the case, about the defendant, whatever, not just about like lunch, then the credibility comes up. So if every juror comes in and says, no, the clerk never talked to us about the substance, which seems unlikely based on the affidavits, but it's possible, then we don't even get to this step. Do not pass go. But if we have jurors saying, yes, the judge said, or the clerk said XYZ about the defendant, then you have to ask the clerk, did you say this? And then the clerk can be impeached. And then the impeachment comes up. Well, did you make up this Facebook post? Did you plagiarize a book? Then the credibility comes up. Because then the court has to decide, do you believe the juror or do you believe the clerk of court? Whose statement do you believe? And how much weight do you give to those statements? Because you're essentially weighing the statements of two people in a conversation. This is literally the basis of all reality TV ever. You said this. No, I didn't. You said that. No, I didn't. It's all, you said this, they said that. So how do you weigh the credibility of who you believe if you don't get into the credibility of the clerk of court when fuckery is clearly afoot in some way? Even the emails, to me, the perjury is a problem. Like, the perjury is a real big problem when we're talking about credibility. When you're selling a book with an article you ripped off in it that was sent to your email that now the whole world can see because that email's been made public. But there's other fuckery afoot beyond the plagiarism. Because the court was supposed to be first come, first serve seating with a limited amount of, plagiarism. Did I say perjury? I meant plagiarism. When the seating is supposed to be first come, first serve with limited seating for the designated media, we know that didn't happen based on the emails. So even then, this process is supposed to be first come, first serve, but Becky Hill used her position to grant favors to those she wanted to grant favors to by saying, oh, we'll get you a pass for today. Come to the side door. We'll print it out and it's fine. You skip the line. It's not first come, first serve. But the judge ruled it was first come, first serve. So there's these little moments when you're like, okay, but what else are you using your position to do? And then there's the ethical complaints. So it's and then. So you can't, when you're looking to weigh the credibility of a person, and then, because these things go to dishonesty. Passing off someone else's writing as your own goes to dishonesty. That's not an honest thing to do. All right, let's keep going. Every portion of Murdaugh's motion relating to Facebook post is a red herring, and the state has moved to strike every part of the motion related thereto. If Becky Hill has to testify, it's going to come up. Did she maneuver like a snake to get a juror excused? But it uncovered other issues. This is what happened in Depp v. Heard with Deuters, right? The court started inquiring as to witness really early in the trial, as to witness Gina Deuters. Deuters, same. And the court brought her up to ask her questions about a post that she made. And we know that post was brought to defense counsel's attention by someone on one of Amber Heard's friends. The closeness of their friendship is vastly been debated. But It was brought to defense attorney's attention that there was this post. Now, the post, as it comes up later, was not a post made during the Depp Heard trial. It was a post made during the case in the UK. But the judge started inquiring of Deuters and asked if Deuters had seen anything about the trial. And Deuters was like, well, I've seen clips. And that was the end of it for the judge. The judge is like, you're not supposed to see clips. So even though the basis of why the judge was inquiring was a false basis, which it seems to be here too, that the Facebook post is not right. The answer was yes, but this juror also talked to other people that she was landlording for or whatever about the case. The Facebook post just was the door that opened. But what happened after the door was opened was that there was other impropriety that got this juror kicked because they were talking to people. Same thing with the witness testimony. The post that wasn't a thing opened the door. And once the court asked the question and the answer was out there, then it was over. That's what's happening here. You can't close that door. All right. It goes on to say Murdaugh attempted to challenge his own valid conviction. Murdaugh's attempt to challenge his own valid conviction cannot be a vehicle to issue witness subpoenas to those with no testimony relevant to the underlying question of whether improper contacts occurred and whether prejudice flowed therefrom. The relevant questions are for the jurors, and their questioning must be judicially directed if it must occur at all. Yes, it should be judicially directed. The clerk of court needs to be a part of this. Potential exhibits should be limited. The state proposes few exhibits are relevant to any potential evidentiary hearing. The state asks the court to consider as exhibits or otherwise part of the record, the transcript of the trial, which in particular includes Judge Newman's repeated instructions that the jury base their decision solely on the evidence, the in-camera hearings regarding the removal of Juror 785 and the jury's verdict and affirmation upon polling, depending on the court's ruling as to the nature of the inquiry to be conducted, and only if the results are limited, questioning of the jurors requires, additional examination may be necessary from jurors and other witnesses. It would have to go jurors first and then witnesses. But that witness is going to be Clerk Hill. Exhibits should also include recorded interviews, written statements, and memoranda of interview with the jurors, as well as the interviews and testimony from clerk staff and others conducted by SLED following the motion for new trial. Finally, as the state noted during the conference call, it's prepared to share the post-trial interviews with Murdaugh attorneys, but must request a protective order as discussed during the conference call and provided concurrently with this filing. The state also concurrently files a motion for reciprocal discovery to be provided. Similar information gathered by the defense in their filing, signed the attorneys on this case. This is such a mess. Like, it's such a mess. It's such a freaking mess. And we're not even done yet. Because there's still all the evidentiary stuff going on with the Becky Hill stuff. The ethics complaints and the response to the ethics complaints and the email dump. When I finish the email dump and finish going through and redacting phone numbers and stuff out of it, I will pull some of those up and we'll go through some of those emails. Why? T. That's why. Or T. We're going to go through it for T. And we'll go through Becky Hill's response. I have some questions about how that response became made public. And I want to look into that a little bit more because it seemed odd to me that response, and it looks like it's a draft, became public, and I have some questions about that. But the plagiarism stuff we're absolutely going to talk about. So let's talk about Becky Hill's plagiarism, because again, this hearing is going to come down to, did Becky Hill communicate with jurors? And if she did communicate with jurors about things that were substantive, then what is her response to that? She's already denied it, but this is a mess. And if Becky Hill was abusing her power as an elected official to grant favors to those she wanted to grant favors to, and was comfortable talking in her email to people like, do you think he's innocent or guilty? That's going to come up when the judge has to make a decision about whether what she said to these jurors happened, or if the jurors are misremembering a comment about body language. There are large constitutional issues here, and the repercussions are that if Murdaugh gets a new trial, it is deeply expensive for the state of South Carolina. Retrials are long and tedious and arduous. I've done retrials. It's a whole thing. And there's the opportunity for the trial to go differently. That's why there's a retrial. But if Becky Hill made these statements to jurors, and it's proven that she did, I don't know how you get around not just a new trial, but a criminal investigation. I don't know how you get around that. And then when you add the wiretapping shit on top of it, does the wiretapping tie into this? And did Becky Hill know that people within her office were turning on her? And it seems that way. It seems that she might have known that. And then her son is the IT department for the county. It's such a fucking mess. But I want to see this hearing. I want to see what the court does. I'm very curious. We're going to look at not the wiretapping. We're going to look at the plagiarism real quick and Becky Hill's statement about it. And then I saw a lot of you in the comments saying that the co-author was just on Court TV. So we might pull that up and do a little reacts to that as well. So let's see. This is a screenshot. Where did this screenshot come from? Did this come from the Twitter? The Twitters. So this is from the Twitters regarding the plagiarism. Did I swoop? I don't know. To the Twitters. Hold on. Come here, screenshot. What are you doing? What are you doing? And then we've got to get to questions. From Justin Bamberg. Please attribute the following statement to attorney Justin Bamberg. No, stop it. User error. Please attribute the following statement to attorneys Justin Bamberg and Will Lewis regarding plagiarism allegations against their client, Colton County Clerk of Court, Becky Hill. Quote, Becky Hill is deeply remorseful regarding an allegation of plagiarism that has recently surfaced from her new book, Behind the Doors of Justice, The Murdaugh Murders. The pressures of developing additional content under tight time deadlines resulted in Ms. Hill taking material written by BBC reporter Holly Hondrick and submitting it to her co-author Neil Gordon as if it were her own words. Okay, so those aren't alleged plagiarism. That is plagiarism. That's not alleged at this point. Also, this is a self-published book. So the deadlines are self-imposed. Like, this is, as Ian Runkle would say, this is an own goal. Rebel said, wait, she's still employed? She's elected. She's an elected official. Lyndon, that literally doesn't make sense, though. She's self-published, right? These are self-imposed deadlines. This is what this is. This is a strike while the iron is hot. Ms. Hill accepts full responsibility for this unfortunate lapse in judgment. I would rather you use ChatGPT. I would rather you use ChatGPT than this. And has personally reached out to Ms. Hondrick to express her sincere apologies. Ma'am, your writing was just so good. I wanted to do it too. The self-published book is only available online through Amazon and Audible, and the decision has been made to unpublish the book for the foreseeable future until next steps for the book have been identified. Ms. Hill has great respect for the tireless work of journalists. Well, some of them. Ms. Hill has great respect for the tireless work journalists do every day and sincerely regrets using Ms. Hondrick's words as her own. This was emailed to her email. This was emailed to her email. Do you guys want to see? Do you want to see it? Let's go do that together. Let's do that together real quick. Because you're going to have thoughts. I have thoughts, we're going to have thoughts. And now we have exhibitees. I have exhibitees. We have exhibitees. There are exhibitees that exist. So let's just do it together, shall we? Where is... Oh... Where is there's a Post and Courier article that I'm looking for because I'm not going to go through all the emails at the moment. So there we go. The Post and Courier article has a snippet of this. All right. To the Post and Courier we go. This is from December 26th. All of this shit broke down over the Christmas holiday. Literally a mess. Oh, also, if you're in South Carolina, tornado watch issued for nearly all of South Carolina as the state braces for high winds. Be careful out there. Watch Ryan Hall, y'all, to stay in the loop. My favorite weather streamer. Yes, I'm a nerd and I like weather streamers. Court clerk Becky Hill admits plagiarizing part of Murdaugh trial book from BBC reporter. Colton County Clerk of Court Rebecca Hill admits plagiarizing the opening section of her book on the Alec Murdaugh double murder trial after her co-author suspends sales and vowed to never work with her again. In a December 26th statement, there's literally no chill over the holidays this year, Hill's lawyer said she lifted much of the book's preface from a BBC reporter's work, saying she was under pressure because of tight deadlines for the self-published book. Attorneys Bamberg and Lewis say Hill was deeply remorseful for her unfortunate lapse in judgment. Is this the statement that's going to come out when she has to testify about the jury tampering? The plagiarized passage were unearthed by Hill's co-author, Neil Gordon, after messages from Hill's government email account were made public early in December. The plagiarism scandal deepens the trouble facing the embattled clerk, who already was accused of ethics violations and jury tampering. Earlier in the day, Gordon, who has been one of Hill's most vocal defenders in recent months, said he would not work with her again after she privately admitted stealing from the BBC reporter's draft. The preface to the book, Behind the Doors of Justice, closely resembles two drafts a reporter mistakenly sent to her. Each begins, for instance, describing Murdaugh as looking bored during his trial, hunched over the defense table, and whittled down by months in prison. Each described the Murdaugh family's power over a, quote, flat expanse of marshland, palm trees, white clapboard churches, and porch-ringed homes. The book's preface even has quotes from several of the reporter's interviews, including at least 4 quotes from former U.S. Attorney Bill Nettles, 3 from Lexington lawyer Eric Bland, and 2 from University of South Carolina professor Randy Covington, and 1 each from Columbia attorney Joe McCullough, the one who's representing the jurors that seem favorable to the defense in this case and who threw Becky Hill a birthday party, and an unnamed witness and 2 different trial attendees. In one instance, a quote's attribution was changed. A woman attending the trial, whom the BBC reporter described as Linda from Hilton Head, became Ruth from Walterboro in the book. She's changing quote attributions. The emails Gordon reviewed were released to media outlets in response to a FOIA act, and they revealed that the BBC reporter, Holly, didn't intend to share a copy of her work with Hill. Hundrick emailed Hill in late February asking her to delete the last draft. I have an editor named Rebecca, and I confused the addresses to which I sent it. It looks like the reporter's email auto-populated the wrong Becky. 11 minutes later, Hill responded that she would. I will do that, but what a well-written article, really good. Hill did not delete the draft, however. The next day, she forwarded a copy to her personal email and to the publisher of a local paper. She later described it as, quote, something a friend of mine is writing. I saw that in the emails too. She forwarded it to herself and said something a friend of mine is writing. This reporter does not seem to be a friend. And the reporter said, please delete. Becky seems to want to elevate her own self-importance through these connections. We're going to go through the emails back and forth with Nancy Grace. Becca Boo seems like a big fangirl. The only emails I've so far seen her sign as Becca Boo is when she's gushing over Nancy Grace. Hill did not delete the draft, forwarded it to herself. Hill's attorney said she has contacted Hondrick to apologize. The BBC declined to comment. Hill was already under scrutiny after Murdaugh's legal team accused her of jury tampering allegations that are at the center effort to win the 55-year-old disbarred attorney a new trial in connection with the killings of his wife and son. Hill is also said to be facing 2 complaints to the state ethics commissions. We've seen leaks of those. It seems like the Post and Courier is not willing to stand behind those leaks yet because the state ethics commission is like, we don't comment on ongoing investigations. So the Post and Courier is saying it's being reported elsewhere, but they're not stamping that as fact. And agents with SLED seized her phone in November on the same day her son, Jeff Hill, now former Colton County technology director, was arrested and charged with wiretapping of another county official. County officials have come to believe he was snooping on his supervisor, records show. That supervisor has emails back and forth with Becky Hill during this trial too. Gordon, publisher of Augusta Business Daily, said the book was no longer being sold. It was, because I was able to buy it. Hill's attorneys said the co-authors hadn't decided the next step for the book. In an interview, Gordon said the book sold 14,000 copies, including digital versions, before being pulled. Quote, "As a veteran journalist myself, I cannot excuse her behavior, nor can I condone it," Gordon said in a statement. The emails in question show that reporter Hondrick on February 14th and 20th sent Hill the text of a draft story she had authored on the trial after the clerk had assisted her in getting pool photographs of the proceeding. The emails show that Hill then forwarded those emails to her private account. The messages Gordon discovered were contained in a trove of some 2,100 emails. It's 2,100 pages of emails. I don't know if it's actually that many emails. Let's see. 2,100 emails Colton County released to reporters covering nearly a year's worth of email correspondence. They began with preparation for the trial. Let's see. In an interview, Gordon told the Post and Courier he felt compelled to read the emails once they were made public. He's nosy. We're all nosy. I get it. You're curious. On his second day of going through them, he said he encountered the BBC draft and was struck by how similar it sounded to the preface, which Hill wrote alone. Gordon said that the preface was first floated after he and Hill were past the self-imposed May deadline to finish their self-published book. They hadn't reached their target word count. He sent Hill a PDF of the article. He said Hill sent a PDF of the article, which she indicated she had written, to their editor, suggesting to include it as an introduction to the book. To acknowledge her singular role in the preface, it ends with a personal sign-off, written as if the piece was a letter to the reader. Rebecca Becky Hill, Clerk of Court, Colton County, South Carolina, 2023. The preface differs somewhat from the final article the BBC published after Murdaugh was found guilty by March. By then, the news organization had made changes to the draft, and Hill's editor had too, Gordon said. In Hill's version, it ended with a nod to the unending surprises the Murdaugh story had published. It continues to, and predicted more. Yep. I guess we'll wait to see if any other twists reveal themselves and take the Murdaugh saga in another surprising direction. You're the twist. You've become the story now. You're now the twist. To the chat, yes. Oh my God, Becky. Yeah, that's where we're at. That's where we're at. The book is now not available on Amazon. Thank you, chat, for letting me know. Right after this happened, I went and grabbed it. It was still available on. Look, it's evidence. We needed the evidence. Wolf Kiara said self-fulfilling. Seems to be. So let's go to this article and let's go to this email. We're not going to go through the whole thing. We'll get to Q&A. Again, this is from the Post and Courier. This is Rebecca Hill forwarding it to Becca Hill at beccaboo68 at Yahoo. This is her private email, but she's doing court business from it, so that's probably going to get unearthed as well. It says, "Hi both." And it looks like this is another person at BBC UK from Holly at BBC. Text is with photos. The text is pasted below for reference. Thank you. This has nothing to do with Becca Hill, but she's forwarding it along as if it was sent to her. On the 12th day of his murder trial, Alec Murdaugh looked bored. Mr. Murdaugh sat hunched at the defense table in the second floor courtroom of the Colton County Courthouse in Walterboro, South Carolina. He wore a dark blue suit, white shirt, no tie. His thin, rimless glasses perched on the very end of his nose. Sometimes he looked up at the witness speaking ahead of him, but mostly he looked down. Months in prison had whittled down his formerly heavy frame. Once a towering figure, now Alec Murdaugh looked small. Preface: The trial in Colton County. We're now going to the book. Hold on. I'm gonna leave this up on the screen so y'all can see it. Let me make it a little bit smaller. The type is so small. On the 12th day of his murder trial for the death of his wife Maggie and son Paul, Alec Murdaugh looked bored as he sat hunched over the defense table, spelled in the American way, in the second floor courtroom of the Colton County Courthouse in Walterboro, South Carolina. He wore a dark blue suit, a white shirt, and no tie, while his thin, rimless glasses perched on the end of his nose. Sometimes he looked up at the witness testifying ahead of him, but mostly he looked down. Months in prison had whittled down his formerly heavy frame. Once a towering figure, he now looked small. So it goes on for the entire preface of this book, which is this article for, 7 or 8 pages. And it is signed off Becky Hill, Clerk of Court. I'm not going to read the whole thing, but it is word for word. There are some minimal changes, but it is this draft from the email, which she has admitted to. It is not inspired by, it is ripped from this email. And there are 2 of them that were sent. And then I saw the other email that was, please delete, this wasn't meant for you. And it was, okay, I will, but it's a great article. Becky Hill is not going to recover from this. Not easily. Between the ethics complaints, the plagiarism, I don't know if they're going to, I don't even know if they have a procedure to recall elected clerks of court. It's a mess. Whatever happens with the new trial, which is also a mess, this is a separate mess. And this is not going to stop. Her son is back in court for the wiretapping. Her phone has been taken by search warrant in the wiretapping, which implicates she is at least enough connected to it that there was probable cause to get a search warrant for her cell phone connected to it. We are definitely not done. We are definitely not done with this. Were there earlier complaints? The complaints that we have seen seem to come after the trial. And those are leaked. Again, those are leaked complaints because the Ethics Commission will not comment on them. This is an absolute mess. It's an absolute mess. So we are definitely not done in South Carolina. We're going to be there all month and maybe longer. Let's see. Vanessa asked, did the defense know or suspect this before the trial ended? It doesn't seem that they did. And the prosecution has been trying to pin them down on that because the prosecution said, when was this newly discovered evidence discovered? Because there's been some insinuation that the defense may have been aware because the defense hasn't said when they discovered this evidence of the alleged jury tampering. But Jim Griffin said in an interview that they were told to look more closely at the jury, like at the end of trial, but nothing more came of that. So the way that the plagiarism came about is that Literally no one was asking. No one had connected these dots. The emails had been out, but no one connected the dots. And her co-author put out a statement saying she plagiarized the book and I am disavowing her and the book and taking it off a sale. Like the co-author just said it out of nowhere. And the co-author has been going on mostly Court TV, I don't know if elsewhere, defending Becky Hill, going after others that were saying that she did anything improper. They're like, she is a wholesome, tireless public servant, and she is being maligned by these fancy ass big city attorneys, and it's unfair. And then like blah 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 blah. Like all the rest of it came out, and it's a mess. So, Jordan asked, can you remind us when the book was published relative to the trial ending? No, I don't know when the book came out. The trial ended in March 2023. The copy I have says September 12th, 2023. So 5 months, 6 months after the trial. But I can go look on Amazon. So 5 or 6 months after the trial. All right. Let's see if the let's see if the co-author's statement is up. I want to see if the full statement is up. And then we'll go look at the interview because I'm just invested. But I'm looking for like the full released statement, not the chopped up statement. And all I'm seeing is chopped up statements by other media outlets. I don't know where he released a statement or if he just like sent it out as a notice to the media, but that all went down on December 26th. Let's just go to Court TV and look at his interview. So she was outed by her co-author. That's how this all came to light. I'm sure somebody would have connected the dots at some point. Let's see. So let's go to Court TV. Oh my God, this says it's 43 minutes long. Y'all, is this really a 43-minute interview? No, okay. It's only the first segment of the interview. All right, let's go to Court TV and take a look at this newsworthy interview of the co-defendant, because I'm not done. Let's see. I'm not done. I'm not done yet. I'm not done. Wait, that's not what I needed to do. This plagiarism story is absolutely bananas, and it's going to come up and bite Becky Hill square in the ass when this hearing happens, if this hearing happens. But it seems that the hearing's happening because the judge has set a date for it. So it seems like there's a hearing. So let's take a look at what Court TV has to say.
Arguments. We're going to begin this hour in the low country of South Carolina.
Okay, this is,
he's getting ready.
This is probably last night's closing arguments with Vinny. I'm going to put the closed caption up. I'm trying not to cover anybody's face, but I want y'all to be able to see it.
Brand new trial. He was convicted in the trial that everyone watched, the biggest trial of 2023, the biggest trial in the history.
Yes, because Depp Heard happened in 2022. Y'all did watch it, and you made my channel the #1 place to watch it, which was really fun. So thanks, y'all. It might be the biggest trial of 2023 and 2024. We'll see.
Of the state of South Carolina, and one of the biggest cases we've had here on Court TV in quite some time. Well,
because it's wild.
He is alleging that the woman who read the verdict to
Lizzie,
the world,
I want to know more about
Hill,
this.
the court clerk,
I want to know more about that.
Interfered in this case and interfered with this jury during the course of the case before his testimony. Also interfered.
Also, she's got the verdict forms flipped. But I never noticed this when the trial happened. Hold on. I'm trying to embiggen and I can't. But she's got the verdict forms flipped so the writing's out. Normally the clerks keep the verdict forms, if the clerk reads it, in a folder so you can't see through the form to see what it says. But she's got it flipped out. Okay.
In the course of deliberations, and then wrote a book about all of it.
Yep.
So, this hearing, she will be obviously in the middle of all of it in this hearing.
She's in the shit that you can't put back in the horse at this point.
Before a brand new judge when she will be called to testify about what happened.
Yeah.
She may or may not even say anything. I don't know. I don't know if she's going to take the fifth, if she's going to speak, if we're going to hear it.
Can you imagine this? Like, this is the end of the month. I can't wait. I'm so ready.
Put up on the screen what the defense thinks should happen here. The defense says she
no,
does not need to be
we just did that.
Scrutiny.
I want to go to the co-author. Let's get to the co-author.
Were not her own work. Was not her own work.
There we go.
Now, you saw the book cover there. She wrote the book with someone. Neil Gordon is his name. He's been on this show before.
Yeah, a lot.
And I had asked him.
There was a knockdown, drag out fight one of the nights, Neil Gordon. A bunch of you sent it to me. The way that I appreciate y'all when you're like, girl, have you seen this? Thank you. But there was like a yelling match going on with Neil Gordon and a lawyer that does stuff on TikTok. And it was absolutely banana. Like, it was bananas. It was bananas. So for those of you saying that Becky wants her 5 minutes of fame, she's getting 5 minutes of infamy. I mean, I don't know if that's the same. I don't know if anybody wants 5 minutes of infamy, but that's where we're at.
And what it was like to work with Becky Hill and what type of person she was. Take a listen.
But we felt it was a story that should be told. I mean, in my lifetime, I'm 59 years old. I don't know that there will ever be another trial like this. And it was my honor and pleasure.
There will be. There will be another murder that captures the public interest. Maybe not in South Carolina, but there will be.
To work with somebody with such integrity and character as someone like Becky Hill.
Well, she's now been accused of plagiarizing all of this, and we know the allegations coming from the defense, so.
She admitted, Vinny. I appreciate you. I'm sorry. I didn't mean to dirty pause. She admitted it. She admitted it. She admitted it.
Want to bring back in special guest joining us, co-author of Behind
I
the
want to hear
Doors
this.
of Justice
Yep.
and Murdaugh Murders, Neil Gordon.
Well done to the
back with
producers
us.
of Closing Arguments.
Neil, great to see you tonight.
We've got questions.
I have to get your response because you've spoken glowingly about Becky Hill, but now
Sir, what do you have to say now? Because Jesus.
you've learned a little more that part of the book that she wrote, she didn't write. What are your thoughts about the plagiarism, and has your opinion of Becky Hill changed at all?
Well, I was so caught off guard. You know, there was a FOIA request.
You went looking through all the emails and then brought it to the media's attention when you found it, sir. Like, I realize that you might have been caught off guard. But like, this wouldn't be in the media if you didn't bring it to the media. It would have eventually come out, but it came out because he was just like, whoomp. You started all of this.
Where probably 2,100 pages of her emails were brought out. And a couple of weeks ago, just before Christmas, I read through them like so many other people. And I just, I was so shocked when I saw correspondence between her and a reporter from the BBC. And the BBC had accidentally sent her a draft of an article.
Twice.
Thinking that she was sending it to a different Becky back in the BBC newsroom. And I recognized the
like, chat, raise your hand if you've ever done that when your email auto-populates like the wrong email address. To varying levels of embarrassment. That has absolutely happened to me when you type in somebody's first name and it just populates it and you're like, shit, wrong one.
Content in the copy right away. I immediately went to the book and I noticed that that was ostensibly what our...
The same. It's the same. It's the same. It's the same. It's the same. Everybody is like, yeah, done it. Every chat, yes. This is self-preservation for the co-author. Might be. He is definitely verbally and loudly jumping ship. He did go on every show he could find to defend Becky Hill. And I don't know if that's because he was defending his credibility or because he was defending the book. There were things I saw that I didn't love in the way that he was doing that, putting it mildly. But he was a very vocal defender of Becky Hill in all of this. So I think he is trying to very notably distance himself now that the ship seems to be sinking. He's running off the ship before it goes all the way down.
Preface was, and I called her up right away and I said, Becky, I said, that's plagiarism. We can't do that. It's
I just picture him being like, Becky, that's plagiarism. And she's like,
What? Wait, wrong voice.
What? It's just like they wrote a thing, and then I was like, oh, that's a good thing. So I should like write that thing. So I don't really understand why it's like a big problem. They're like the BBC, like nobody's gonna notice. Like it's just a little book. Why is it a problem?
absolutely improper, unethical, and just surprised.
He calls her unethical. Do you think that's going to come up in one of these filings? And her co-author called her unethical. Or do you think it's going to come up in the ethics commission? Or do you think she's going to end up getting arrested in this wiretapping fiasco? Like, what happens next?
Me, despite all of the various things that you hear, it's been so many months together just working on this book, and I was just really disappointed and really shocked, felt betrayed. And
well, you have very vocally defended her on every camera you can. So I imagine that there's also a level of embarrassment wanting to clear your name too, maybe.
Sometimes, Vinny, in life, you think you know someone and then other things occur.
Like everyone that ever knew Alec Murdaugh. Sometimes you think you know a person, and then it turns out that you don't. Every Murdaugh witness ever was like, I guess I didn't really know him.
And it maybe wasn't the person that you thought that they were. And we'll see how everything plays out.
Not well.
But it was certainly very disappointing.
Does it make, in your mind, it more possible that maybe she did say some of the things?
Sir, is she a lying liar that lies?
Defense through these juror affidavits that maybe she had.
Vinny's just going there.
Some improper things to the jury.
Go on, Becky.
I wasn't there. I don't know. Everyone is saying what's happened with the book and what she's being accused of in so many other different situations, whether it be using her office for personal gain, whether it be something to do with the phones that she was supposed to be turning in to SLED and wiretapping accusations. All of those things matter.
We haven't even gotten into it today. We'll get into it another day because there's more I want to look at, but there's allegations that she did not turn over all of the phones or the correct phone to SLED when they had a search warrant for her phone.
Counted, certainly, you've probably read and seen, doesn't put her in the best light. So I don't know.
I would like to distance myself from all of it.
That's exactly what Judge or Justice Toll is going to discuss a week from tomorrow when she gets all the attorneys together. And then if she decides to have the evidentiary hearing on the 29th, 30th, and 31st, Becky will get a chance to answer those or not answer those charges.
Allegations, but we'll see.
Well, let's ask you this, because you're connected to her now to a certain extent, right? Your name's, and you spend a lot of time with.
Then you just be like, you've been on this program again and again and again talking about this. Come on.
With her. Do you think there's any chance that either side might subpoena you and might call you in to testify? And if so, what would you have to say?
Well, there was, I think, a 21-page order that came out between both the defense and the prosecution recently. And I believe in one of Dick Harpootlian's paragraphs.
If she resigns, how she's going to get paid? I think Becky's going to stay in office till she gets pushed out of office, because how do you find a job in the middle of this going on? No, I think she's holding on to the fact that it's impossible to fire her at this point forever.
He said that he was going to perhaps look through passages of the book to see if that had any significance or not, and speak to people associated with producing the book. So I'm assuming that's me. So my phone number is 706. No, I'm just kidding.
I was like, please don't. What are you doing?
I'm happy to be honest and be called in and answer anything that I am asked. And have no problem with that whatsoever.
Now, you're a journalist, right? I mean, this has been a big part of your life.
For the chat asking, I have not seen an impeachment or a recall process for the clerk of court. South Carolina might not have one, because who would have thought that this would ever come up? That the clerk of court was doing so much. So I have not seen a process for that. But if someone is an expert in the election laws in South Carolina and would like to share that with me, my email is publicly available on all of my videos. Please email me.
Written things, you wrote this book. Now you're associated with a book that contains things that were plagiarized. So did you take any action, and what did you do as a result of finding out that your co-author, who you
guys are funny,
thought you knew and you trusted, had lifted some parts of what she said she wrote from somewhere else?
Well, I certainly, first of all, try to give her the benefit of the doubt and asked exactly what happened.
Maybe.
And once she acknowledged that under deadline pressure of trying to provide more
It's such a bullshit excuse. I am daily under deadline pressure to go walk on my treadmill. Every day. I'm like, I really love my Ring in the New Year challenge with Apple. I really should go do it. Like, I really want to go do it. And every day, somehow, I don't do that. But also, it's a self-imposed limitation. It's a self-imposed limitation. Under the deadline pressure that we set ourselves for our self-published books. Stop it.
Content. She did go back through her email and she did lift the material and send it in. And once she acknowledged that, I immediately contacted my attorney. We had a conversation. I then called back and spoke to her husband, who's our business partner, and we decided.
Wait, the husband's also a business partner? I've got questions. I've got more questions. What role did the husband play in being a business partner?
To immediately
I have questions.
Ask Amazon to unpublish the book and the audiobook, the Kindle version, any versions that we had. And then in addition to that, we reached out to the writer of the article in the BBC and apologized and explained what happened. And then we reached out to our insurance carrier to put them on notice, because we carry errors and omissions insurance coverage.
In case we're sued.
So we went through that entire process. And Vinny, what we learned, and maybe this is the genesis of being a self-published author and dealing with Amazon the first time, is we had such success.
I'm waiting to see if this is Amazon's fault somehow.
Of selling thousands of copies each month, that Amazon felt comfortable that would continue for the foreseeable future. So they warehoused books. And in the fine print.
Vinny's like, ooh, they warehoused books. And?
In their contract, they are allowed to go ahead and liquidate those books, even when you say, please stop, no more.
So that explains why they were still available, because they had, it sounds like, to ship them out faster, because I imagine when you self-publish that there's a certain drop shipping component. Like, the books aren't actually made into form until people are ordering the books. But to get the books out faster, they published physically and bound the books of a certain number, and those books are still hanging around. So it sounds like those books are still hanging around, and that's why they might still seem to be available.
And so even though we unpublished it and they are not printing any more books, they
They're
have
selling through
liquidated all
stock.
the hardcovers, and there's no more audiobook or Kindle for sale. But even today we had a few paperback books, and there's been almost 900 books sold since I discovered on December.
I like that he's like, whatever lawyers from the BBC might want to sue. Since we discovered that there was plagiarism, we've sold over 900 books. I was one of them because I was like, shit, this is going to get unpublished and then we won't have it to compare.
December 22nd about the plagiarism. And, you know, we've kind of taken a big hit on social media. You mentioned we're kind of inextricably tied to Becky. And
Sir, you went on to beat the drum in this woman's defense as much as you possibly could. So if you're taking a beating on social media, it's probably not just because you're the co-author, because if you just had your name up here, I don't know if anybody would know who you were outside of the circles that you run in South Carolina and the journalism circles that you run in. The wider world of social media might not have paid attention, but you went on TV show after show after show, riding like Heather Gay rode for Jen Shaw. You were riding for Becky Hill. And then all of this came out. So yeah, that's social media is going to social media.
This book, and we don't want to take any of that money. I mean, that money, the book was supposed to be stopped. So we don't want to take any of that money. And, you know,
maybe ask the BBC what they would like to do.
After expenses and, you know, our proceeds, our net proceeds, our share of it is.
This is the media pool in the jury box in the courthouse before the plea and sentencing.
A few dollars a book.
Courtroom.
So we're going to donate that money to some charities in the Low Country. There's a lot of really wonderful foundations and scholarships set up for children to get a good education. You know, some pockets of the Low Country are very poor. And so it's something my wife and I want to do. And if you will, try to make something good happen of what I think was very bad and what occurred just before Christmas.
Well, Neil, I always appreciate your honesty and willing to answer any questions that I throw at you. So thanks so much. I think
they were pretty gentle questions.
Now that you stop publishing, people that have those books, they'll probably go up in value now because it's a collectible. You can't get it anymore, right?
Vinny, stop it. It's not a collectible. Emily is unpublishing, tampering with evidence. I mean, if he hasn't deleted the manuscript and if they haven't deleted all of that work, no. It's also not evidence of a crime. This is a civil thing, but he has, as Tina pointed out, pledged to donate.
Well, the only time we had this level of sales was when we launched it.
From the courthouse?
And after I went on the program, remember Dick Harpootlian had the press conference. It seems like when there's some kind of...
When the media is all involved, Dick Harpootlian did have a press conference and was just like, and this book, and then everybody's like, I want to see what's in the book. Trisha said in the chat, Vinny just wants to sell his signed copy on eBay.
Volatility going on or controversy, people like to get it, and you're right.
Well, people are trying to get those last few copies that Amazon has right now, probably.
I'm people. I'm people.
As we speak. But Neil, thanks so much. Appreciate it. I'm sure we'll speak again as we get closer to this date. Have a good night. Thank you.
I don't know if the BBC could try to recoup the profits that they made. I don't know if they will if it's been unpublished. I don't know what they're going to do. Did you see there's a book about the book? No, I didn't. I think this is the sign off of the interview. So let's look at that. And then we're going to get to Q&A because we've been streaming for almost 3.5 hours.
You too, Vinny.
All right, let's bring in our...
All right, that's the end of that media report. From Court TV. I've got questions because it seemed so strange to me that the co-author was just like, I was going through these emails and I saw some plagiarism and I was like, whoopsie doodle, there's some plagiarism. Like, it is so odd to me. It's just so odd to me. But no, I didn't see that there's a book about the book. I knew it, a book about the book. I mean, I just downloaded the book about the book. I need to know. How much does the paperback cost? I have no idea. Emily, how do you feel about now being Housewives adjacent? I don't know if I'm Housewives adjacent. I like watching it, but I don't know if I'm Housewives adjacent. Becky's our roommate now. I don't know about that. So, link to the book. I'm definitely not linking the book. It's on Amazon, but I don't think it's on Amazon anymore. Question, do you think Becky's lawyer has a copy of the book? What would you do if you found out your client did this? I think her lawyers made the statement apologizing. I don't know what you do from there. Do I think they keep the book? Yes, because if anybody says there's something in the book, they're going to need to be able to look at the book and see if there's something in there. This is an exhibit now. The book is in evidence. I need exhibit stickers. The book is in evidence. It is Exhibit A for the Murdaugh case because it seems that she does talk smack about it, or talk smack about the jurors. So we need to know, we need to read the book. I just, up next, the BBC won't let me be. All right. So bait stamp it. I'm going to put an exhibity sticker on it and bait stamp the pages. So not that I'm telling you to sell the book or buy the book. I'm not advocating buying the book that we know is plagiarized. I imagine that the BBC will have some conversation about what to do with the profits of the book. But it's so strange. Yellow Pill said, I think it would be weirder to keep his discovery a secret. I think so too. I just wonder if there was the way it was handled is odd to me. That's all. It was like the whole thing was odd to me. So it was just odd. The way it all came up, I'm like, this is just strange. But no, do I think he should have kept it a secret? No. Do I think going immediately to the media with it was strange? Yes. Do I think he should have unpublished it, alerted the BBC, and then dealt with it? Maybe. So I don't know what the BBC is going to do with this, but I don't think he should promise to donate those funds yet, because if they end up in a lawsuit, somebody's going to have to pay for it. All right, let's get to Q&A. Y'all, let's do it. Before I go, hit up Starbucks for Triple Star Day, or at least it's Triple Star Day for me. I don't know if those things fluctuate or not, but it says Triple Star Day. So I'm gonna go get triple stars. They have a new like an egg bite thing that I really want to try. So I need to go to Starbucks today because I want to try the new like egg bitey situation. That. Emily, how much coffee are you going to drink today? Too much. Too much is the it's Triple Star Tuesday. Correction, it's Triple Star Tuesday. Emily, are you planning your lunch right now because you're hungry? Yes. And I want to go try the potato cheddar chive bites or bakes. I guess they're calling them bakes. I want to go try that. So that's what we're going to do. That's what we're going to do. So tasty. So tasty. All right, let us swoop it up to Q&A and then let us get out of here. We have lots to talk about this week. As a reminder to the almost 10,000 of you in here, do the YouTube bings. And tomorrow's podcast is all Girardi fuckery. And a little bit. Damn it, Emily. That was me. And a little bit of Ariana and Tom. So don't miss tomorrow's podcast. It comes out earlier on audio. I'll be in the chat for the video release. Thursday is up in the air depending on what happens with the Adelson hearing. If it just gets pushed back, we'll just do that. Otherwise, we'll cover other cases. Next week, Tuesday, we've got a lot to cover. Next week, I think next week is when I said we're going to be doing the Scientology podcast episode. If you want to keep in the loop on all of that, you just need to be in the app. We have lots coming for the app this week. Or this year. I shouldn't say this week. Nothing's coming this week other than notifications. But we have a lot coming to the app this year. I'm really, really excited to bring that to you. So If you're not in lawnerdapp.com, lawnerdapp.com, it's a free app. It will notify you whenever I am doing anything on whatever platform. So if I'm going to do a quick Instagram live, it'll tell you. And that's what happened when I opened the Bear Brick, is that it was a spontaneous Instagram live because I'm like, I have presents from YouTube. Let's see what they are. There's content specific to the app in there and the rest of it. So lawnerdapp.com will get you there. Or you just go to the App Store and search for Lawnerd, and it's a free app for you. So free for everybody on iOS and Android. Let's get to Q&A, shall we? I feel it in my bones. 2024 might be the year of find out. I'm going to be disappointed if we get to the end of 2024 and it's not the find out year. I'm going to be sad. It is time for our Q&A. So let's do that. I saw a question in the chat that I did not grab fast enough about the dragon mug from Starbucks. I saw them in Starbucks stores. I don't think they're exclusive to Target. So this little guy for Year of the Dragon, I think you can probably find in Starbucks stores. They were not flying off the shelves like the other stuff is. I think they're great. I love it. I think it's really cute. Spank that like button. I'm here for it. And they're really cute. Question, are you going to get a frame? Sorry. Are you going to get a frame to put the book in? This is very important to know. For now, it's staying with my exhibitties. So on my shelves, I have my Black's Law Dictionary. It's going to stay with reference books for now. Let's see. So YouTube unboxing on Instagram. I did a YouTube unboxing on Instagram. I've been meaning to put the video up on members. I'll put it up here on members for that for sure. But it is, Nikki said, ooh, Bear Brick Elite. It was a gift from YouTube. They're really cool. I've seen a couple people unbox theirs. They have some different colorways. It is customized. It has my name on it. It has my channel on it. It has its own little like lucite box. It was a really cool gift from YouTube. I was blown away. I'm still kind of blown away. So I love it. How does one guarantee an untainted jury pool now? Is it possible? I think it's possible. I think people have to follow the rules. I think that's going to get harder as people feel like, I can't go to bed without like scrolling on social media. And with bigger cases, you could come across case information without looking for it. I think that's a problem. But I think you're always going to find people who just aren't interested. They found jurors for Depp v. Heard, even though he's one of the most famous actors in the world, who were like, I don't know anything about this case. I don't really follow pop culture. He was in a Pirates movie. Like, okay. They found jurors for Murdaugh, and I don't think the jurors were tainted. I don't think the jurors were biased. They're alleging that she messed with the jurors, and that is an issue, a big issue. So Jennifer Haller said they even put in a seatbelt so you wouldn't break it. They did. It was in a full seatbelt. The unboxing is up on my Instagram. It's crazy. What does the bear do? It is a Bluetooth speaker. So that's what it is. The potato chive eggy thing is tasty. Awesome. Amazing. All right. I'm going to get to some of our older questions and I'll get to some of our newer questions. And we'll do that. So we're going to get to some of our, we have lots of super chats. So I'm going to get to some of those. For the member chats, I see them. I don't know if I'm going to get to pull all of them up because I want to make sure we get to our Q&A. Brittany, this is a very important Q&A. What beautiful lip gloss are you wearing today? I was wearing lip liner with lip. It's not lip gloss. It's Laneige lip balm because my lips were super dry. And that's what I did today. So lip balm today with a lip liner. I don't know which lip liner I am wearing because it's like all of it's worn. So I have no idea what color it was, but that's what I was wearing today. Let's see. For all of you, I missed you guys too. It was good to take a break. Thank you all for being so supportive. It was needed. Hey, ADB, have you been following the post office scandal here in the UK? Postmasters were accused of theft, some imprisoned when it was an IT fault. I have no idea. No, I haven't, but I'm fascinated. Rachel said 40 degrees today, -11 Friday in central Illinois. Yikes. Cold. The Danish doll said, I'm at 30 weeks today and on bed rest with the Lawnards. Danish doll, take your bed rest seriously. I'm so sorry you're on bed rest. It is not the most fun, but find things to entertain yourself. And hopefully you and baby are good and well, and everybody gets to cook for just a little longer. I was on bed rest for a while. It was it was a lot. Bed rest is a lot. The irony of Becky misusing her power is a very Murdaugh thing to do. The irony of the entire situation, it's just, is the entire Murdaugh case just an exhibit in power run wild? Maybe. We're going to keep getting into that. Let's see. Question, will you be at VidCon 2024? Tuck will be there again. Yes, I do know what you're talking about. I think. And I don't know yet. I've blocked it out in my calendar. I don't know. I'm probably. As a member of the clerking community, we do not claim Becky with the bad Venmo. Lawnard, so the Venmo was so wild to me when they're like, oh, we didn't get to donate to your daughter singing. Can we just Venmo her? Like, some of these things might have been meant in a really well-intentioned way, but the appearance is that journalists are now somehow paying for her daughter, or somehow her daughter has access to the journalist and they're paying her while she sings. It's odd. It's all odd. And it might have all been very well-meaning and well-intentioned, but when you stack it all up together, I don't like it. Christine D might have just put a pin in it for me. I smell a culture of shadiness. So, let's see. Becca has thoughts, said my name was Boo Boo in high school. I've been Becca Boo since my first internet screen name. This lady is giving us all a bad name. To all of the Beckys, Beccas, Rebeccas, Becca Boos, I'm sorry. You're not getting the Karen treatment. It is not your fault. Courthouse Becky will be come and gone, and we'll go from there. If she's an elected official, how do we eat her? I don't know what the procedures are in South Carolina. They would be specific for South Carolina, and I would have to go through South Carolina's election laws. So I don't know what the procedures are to yeet an elected clerk of court. Alex said, question, never felt like I got confirmed on if Alex killed his family. I thought the evidence pointed against. What's your opinion or summary? The jury found him guilty. I think one of the things that was most pointed for the jury is that the video on the kennel showed that he was there within moments of the fact that the moments of Maggie and Paul's phone, their phones never being used again. So he was at the kennels moments before the murders, like 90 seconds, 2 minutes ish. And so if he was at the kennels that close in time to the murders, how do you not hear the murders, intercede the murders, not get murdered yourself? I think that kennel video and the timing and the fact that he lied about it is kind of what did him in on that. Miss Mandy Reacts, congratulations on starting a channel. Yay. Kit Kat said, wow, I can't believe it's been almost 2 years since I became a Lawnard. Thank you, Emily, for keeping us informed and doing so in a sensitive and classy way. Hopefully with some fun. And you're welcome. And thank you. Jasmine Smith, gotta love small town quirks. My county quarter terms and only has 4 jury selections a year. I practice in super rural Pennsylvania. Yeah, very different than practicing in Los Angeles, which has one of the largest prosecutorial agencies in the world. It's a whole different thing. But it makes sense. If there's not enough, why keep the courts running day in and day out if there's not enough? It's interesting when you see judges like Newman riding circuit, and even in law school when you're reading about judges riding circuit, you're like, wait a sec, they're actually going from courthouse to courthouse. And the Long Beach court did a little of that because they would have one court day for Catalina Island, which was like separate off of Long Beach. But it was always interesting to see. The riding courthouse is very interesting. Is Judge Toll presiding over courthouse Becky stuff? Yes. She's one of the judges that presides over the cases at the firm I work for. Yes, she is. She is the assigned judge to deal with the motion for new trial. Casey Cat says it's because you're smoking hot. I don't know about that. But it's interesting. A juror asking the prosecutor out on a date sounds like something straight out of Ally McBeal. Kind of felt like it. I was I was not thrilled in the middle of my case. I was kind of like, does this happen to men? Do people just think they're approachable? Like, hey, you're at work doing your job. Clearly you want to date me. But it did happen to a number of men that I met, and I saw judges objectify them in different ways than they objectified women. And I'm like, I'm just trying to work, man. Just trying to work. We need a members only dedicated to EDB stories. I mean, I think so. I saw in the chat, Sheila said, I didn't realize that Catalina had its own courthouse. The staff, and this could have changed, but it used to be that a judge from Long Beach, a prosecutor from Long Beach, a court reporter, a bailiff, and a defense attorney, and a few others would like helicopter over to Catalina to do court day in Catalina. So there was a court day in Catalina. Brandy Rose said off topic, and I'm way behind, but wondering if you will cover Sarah Boone. If Sarah Boone goes to trial, we will jump in at some time. So it's on my radar. It's a wild case. Irina, what is depublishing? Putting the shit back in the horse? Well, not successfully, but I think they're trying to. They're trying to make it right. They're like, we've discovered the error, and now we're trying to make it right. Question, would they be able to use the testimony he gave on the stand at a new trial? If and when it becomes relevant, yes, they can use prior testimony at a retrial. Would all of his prior testimony come up? I don't know. But if and when it became relevant, yes, they could. So it really depends on how the trial unfolds. Michelle M. said, 1 more month to a year subscribed. As trash as Murdaugh is, he is entitled to a fair trial. Shame on you, Beckaboo. He is entitled to a fair trial. And this is, again, trust but verify, right? When this came out, it was, hey, these are allegations. If these allegations are true, it's bad. I always want to look at the court stuff and be like, could there be more here? Yes. Do we need to take a closer look at it? Yes. But I never want to look at something and be like, oh, this is just Team Murdaugh trying to find shit where it doesn't exist, because the allegations are bad. If it comes out that Team Murdaugh made some of this stuff up, then that's bad on them, and we'll talk about it. But if the clerk of court is talking to the jurors about not believing Murdaugh's testimony, it's really, really fucking bad. And it's not okay. Bitter Sweetheart said, LOL, that's cute. Minus 52 degrees Fahrenheit in Montana on Friday. Yikes. Kathy said, who is paying for our hotel and food in South Carolina? Bill it to Becky. Bill it to Becky Boo. Great way to spend my day off. Thanks, Kara. Send it to Daryl. Question, do you think the jury will be questioned whether they read the book or not? No, because reading the book after the fact doesn't matter. And I think some of them probably did, but reading the book after the fact it's not relevant to whether or not the clerk of court talked to them during deliberations. The book came out so much later. So Olivia said, just wanted to say thank you, Emily, for the delightful way in which you enlighten us all things law related and tangential each week. You are welcome. Question, would a solution to the book be splitting profit since Ford preface is only a small portion of the book? I don't know what the equitable legal solution is. I think to avoid a lawsuit, I think I would give all the profits to the BBC and be like, here, don't, especially if I'm the co-author, here, don't sue me. Flipping Hot Fine says, question, if the county board knew she was doing underhanded activities, shouldn't they have removed her and appointed the assistant? I don't know if the county board can. She's an elected official. I don't know if that can happen. I don't know if they knew about any of this. All of this seems to have come to light since the trial. So I don't know. Cheryl in the chat says, I bet Becky gave jurors autographed copies of the book. She might have, but maybe not the ones she was talking about, because it's said that she talks about the jurors quite a bit in this. I will be at some point when I'm done going through emails, be going through this. I just haven't had a chance to do it yet. I'm reading the statuses and it appears there are no recall provisions for elected officials in South Carolina. Reading the statutes. Oh, sweetie, no. That's a very interesting thing. And I wonder if that's why we haven't seen anything happen. Paul K says, I hate to sound like a conspiratorialist, but perhaps this was the defense's plan all along. Wink, wink, say no more. I don't know. But it's a lot of shit, isn't it? Mr. Mystery says y'all forget that hashtag Team Bubba and Snapchat proved that he was there milliseconds before they were unalived. I mean, minutes. Nobody else. Just saying Miss Becky and Son is a separate mess. The problem is, Mystery, that whether or not the evidence is irrefutable, and I think this case less so than others, even if, arguendo, evidence is irrefutable, if you have a conviction where the evidence is irrefutable and the clerk of court does this, another case, not the Murdaugh case, and you've got it on video and you've got DNA and thumbprints and a confession and all the rest of it, and for some reason that case goes to trial, and the clerk of court does this, you still may be entitled to a new trial. The strength of the evidence is irrelevant to whether or not the clerk interfered with this jury, because he is entitled to a fair and impartial trial, no matter how close or not the evidence is. So the strength of the evidence is irrelevant, truly, to the analysis of whether he deserves a new trial. Nanner in the chat said the Brooks case, for example, yes, like the Brooks case. You've got the Brooks case. If somebody in the Brooks case did what's being done here, he might be entitled to a new trial, regardless of how strong the case is. Thank you, Nanner. That is a perfect example. The Brooks case is a good example for so many things. Curls in the chat asks, how does he pay his lawyers for a new trial? Well, who knows? Janway, Emily, do they check and see if she's done it in other trials? The defense attorneys would have to bring it up. The defense attorneys would have to go looking for it. There's nobody else really to check. Amy G said the appearance of impropriety is concerning very much. Very, very much. Very, very much so. Emma said, I think Paul is right. I bet South Carolina lawyers were well aware of Becky's weakness based on past cases. They just waited for an opportunity to present herself. Maybe. Boot gets paid in exposure. Hello, J. Michael. Retrial or another Cosby? I vote for retrial. I mean, we definitely don't want it just getting overturned by the court with no other option to retry. At least with a new trial, you get a new trial. Madison said, became a new mom in early December, had a health scare with my baby boy in the hospital for an extra week, and your streams got us through it all. You're welcome. That is a difficult thing to do. I had not watched, this is a sidebar and then we'll continue. McLinda said a bill is introduced in South Carolina to add recall provisions. I imagine that they need that. So I sat down to watch the Take Care of Maya documentary. I don't even news piece. I think it's on Netflix. Everything's on my Apple TV. So I just search for it and then play it on whatever thing it's on. And Dr. B kind of walked in and out of parts. He's like, he's like, this is so hard. Because we've had kids that have had medical stuff. I had, our oldest was a NICU kid. I've talked about that, being in the hospital and what that was like. It hits me. The Maya case hits me really, really sideways. But Dr. B was like, I can't watch any more of this. Like, I can't watch any more of this. It's just, it hits differently. So, all that to say, being in the hospital with your kids can be tremendously hard and very, very scary. So I can. Brianna said, do you think they would re-prosecute? That's yes. Yes. I'm not yes. Yes. All of the yes. The Take Care Maya trial was so hard and the doc made me cry so much. Yeah, I couldn't. I knew I couldn't do the trial, and that's why I didn't do the trial. Rachel Mills says, was in court for Brittany's hearing, and there are some misstatements out there about the depots, and bigger news is Sam Ingham is avoiding calls from Rosengart, needing more info on billing overlap. Well, billing overlap's a problem. Rachel, if you ever want to shoot me an email after those, my email is public, and you are welcome to shoot me an email. I am always happy to hear what you have to say after the court hearings, for sure. Her deadline was before the reporter could release. Beach Please was like, her self-imposed deadline was before the BBC story went out. Lisa said the never-ending story, just like the book. It's such a mess. This is a mess. Like there's no downplaying how messy this is. What I hate is that the mess is now also turning into like sideshow internet drama with the lawyers like pissing at each other on Twitter, and then there's like other personality stuff with people getting into each other's ass on social media that is just not a help to any of this at all. But it's wild. And we're going to keep covering it, mostly the court documents. Occasionally we'll stray into things that are tangential, that are related. The ethics investigation, tangential but related. I want to know how those got leaked though. So there's other things that I'm like, when things seem weird, it's going to take me a little while to process if I want to bring them up or not. So the House bill to recall elected official is currently in the committee, South Carolina House Bill 3256. Do you think this had something to do with it? I'm sure there's others, but it's wild. Lorray said, I think he felt the need to clear his name and protect his career. I think so too. Absolutely think so too. Shelby said, I'm behind in live. In Becky's book, she said that friends of the foreman paid him 6 weeks of what his work salary would have been because he was going to quit. That's weird. That's suspicious. I'd want to know who the friend is because it seems that everybody in the Low Country knows each other. Let's see. Question: If Murdaugh receives a new trial, can defense resurface concerns about finding impartial jury members in Hampton? Oh yes, and they might have a better argument on a retrial. Truly, absolutely, truly. So. Tina K.S. Law Nerd said, thank you, EDB, for your insights, audacity, and fuckery. In this case, will have us living here for all of 2024. Law Nerds, buckle up. We could be traveling to South Carolina a lot this year. Yep. Let's see. Good luck, Justin, with the uphill battle. Thanks, EDB. I mean, it's always fun to get to watch lawyers on both sides, like with clients that we're really empathetic to, and then with clients that we might not be as empathetic to. It's interesting to watch how the perception of the lawyer might change based on how much you like their client. It's really interesting to evaluate kind of your own thought process and your own feelings and biases and what have you when you're looking at like, oh, some of Justin's clients or Justin Bamberg's clients weren't. Am I on a first name basis with all the lawyers on the internet that I don't know? Maybe. But you look at the clients that were victims of Murdaugh and you feel tremendous empathy for them and for him as a lawyer. And when he stood up and spoke at sentencing, there was tremendous empathy there. Everybody was just like, get it. But when he stands up to argue for Miss Becky, are those feelings going to change? Or you're going to be like, good lawyer doing good lawyering, don't like your client. So it's interesting to get to separate those things and start to separate legality and emotionality and morality and how the likability of a client can actually splash over onto the likability of a lawyer and vice versa. It's an interesting thing. So thank you, Law Nerds, for all of the well wishes in your members' chats. These are so much fun. So much fun. So it's good to see all of them. Octo's like, we are still professionals here in 2024. Facts. Let me see. I know we have a few more super chats. I'm going to try to get to them, and then we're going to wrap because I am hungry. Eric said, question: if a new trial is forced, can they ask for additional time so that stuff could blow over since Murdaugh is going to be in jail for 27 years on the financial crimes? Yes and no. There's like a push-pull to that because memories fade, witnesses move, life happens, people pass away. So they don't want to go too long because you can start to run into witness issues and evidence issues and the rest of it. So Kelly said the fact that she went to New York with the jury is sus. Would go to New York with the lady that takes your order at Starbucks every morning, shaking my head. I think Miss Becky was really excited that the jurors were going on the Today Show and really wanted to be there to be on the Today Show. Mm-hmm. How long do we think it will be before a definitive answer regarding a new trial is going to be? Let's see what happens with the hearings this month, and then I'll have a better idea. But it's going to be a little bit. But I don't think it will be 6 months. I think it will be a few months. Congrats to all those finally catching a live due to a snow day. I mean, some are catching due to a snow day, some are catching due to a tornado day. So all of you stay safe. The weather out there today is a whole situation. Editor Danielle Marie said, under deadline pressure is such a canned and lazy response to plagiarism. Yeah, it's an own goal. That's like a self-imposed error. Let's see. There was a ruling in the Tupac case. I will get to it Thursday because I don't have time to read and process and my brain is done, but I will, if I need to do a short on it, I will later. I need to take a break and go eat. That's what I need to do. So, today's show, promo for my book with a book about it. And I get wanting to be there. Like there's things I really want to be at too. Like BravoCon is one of those things I really want to be at. It's where the people are. It's where the things are happening. I want to see it go down. I want to be there. I understand like, oh, this is about this case that I worked on and the jurors are going like, I want to go to the Today Show too. I want to go to New York City. Like I want to go do all of that. I understand the excitement. The problem is sometimes depending on your job, you don't get to participate in some of those things. So that. All right, chat, it is late. I appreciate you. I have got to go. I am tired and hungry, and it's been almost 4 hours. In the new year, we're trying to keep our live stream succinct. Didn't happen today. So with all of that, thank you for being here. Thank you for being Law Nerds. Download the app. I appreciate you, and I will talk to you soon. You guys are the best. I'll see you tomorrow for the podcast, Thursday for another live stream. Oh, 2024 is going to be wild. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.